The chair recognizes the member from Auburn, Representative Osborne, and moves that the House adjourn from the session of February 22nd, 2024. Are you ready for the question? All those in favor say aye. Aye. All those opposed, nay. The ayes have it, and the House is adjourned. The House will attend to a prayer by House Chaplain Reverend Bob Stewart, pastor of St. Paul's United Methodist Church in Manchester.
Good morning, Mr. Speaker. Good morning, New Hampshire House of Representatives. Let us prepare our hearts for a moment of prayer. Good morning, God. On this day in these chambers of the New Hampshire House of Representatives, we give you all the glory and praise. O majestic God, we know that you are a God of love, compassion, and peace. Make us a channel of your peace. Where there is hatred, let us show and share your love in ways that others may see you through our actions. Where there is despair in life, let us bring hope to others through how we legislate change for our state and for our constituents. God, you are the Alpha and the Omega, the beginning and the end, the first and the last. Be with each of us as legislative business is presented before this body today. Help each of us to listen carefully to each other so that we may be able to make sound and careful decisions. Decisions that will hopefully lead to the betterment for all that will be affected. And gracious God, I once again ask that you grant a special blessing upon each member of this house. They work hard to do what is right for the people of this great state of New Hampshire. And for that reason, I ask that you extend them your grace. God, I also ask that you bestow your blessings upon all the leaders gathered here today. Help them to lead in such a way that it will be pleasing to you, O God. Thank you, God, for your faithfulness to us, and may we in turn be faithful to you. To God be the glory and praise. Amen.
The chair recognizes the member from Thornton, Representative Heather Baldwin, who will lead us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The chair now recognizes Miss Louisa Sychterz, a 5th grade student at Waterville Valley Elementary School, who will sing our national anthem.
Oh, say, can you see by the dawn's early light what so proudly we hailed at the twilight's last gleaming, whose broad stripes and bright stars through the perilous fights o'er the ramparts we watched were so gallantly streaming, and the rocket's red glare, the bombs bursting in air, gave proof through the night that our flag was still there. Oh, say does that star-spangled banner yet wave o'er the land of the free and the home of the brave?
The House will attend to leaves of absence.
Mr. Speaker, the day, illness, Representatives Crawford, Ellison, Macbeth, Montiel, O'Brien, Maria Perez, Ryan, Sofokidis, Vincent. The day, important business, Representatives Bolden, Conlon, McLean, Moffett, O'Hara, Payer, St. Clair, and Testerman. The day, illness in the family, Representative Sanborn.
These leaves of absence shall be granted unless otherwise ordered by the House. The House will attend to introduction of guests.
Mr. Speaker, please welcome Alan, Susan, and Kimberly Rawson, Kelvin Sychterz, Morgan Brown, and Gunnar Baldwin, friends and family of the singer, guests of Representative Baldwin. Kira Wood and Peter Villion, daughter and friend of Representative Wood. Jade Flad, guest of Representative Alan Reed. Stephanie Grund, guest of Representative Vayu. And the Honorable Tony LaBranche, former member from Amherst, guest of Representative Wendy Thomas. They are with us in the gallery today.
Welcome to the New Hampshire House. The House will now attend to the consent calendar.
Mr. Speaker, from the Committee on Legislative Administration, House Resolution 25, removed by Representatives Panic, Sellers, Christine Perez, Tom Mannion, Drago, Horrigan, Tensar, McCarter, Seidel, and Yokella.
Are there any other bills to be removed from the consent calendar? Representative Osborne moves that the consent calendar with the relevant amendments as printed in the day's House record be adopted. Are you ready for the question? All those in favor say aye. Aye. All those opposed, nay. The ayes have it, and the consent calendar is adopted. The chair recognizes the clerk.
Mr. Speaker, the Committee on Enrolled Bills has examined and found correctly enrolled the following titled Senate Bills. Senate Bill 317, relative to establishing a New Hampshire-Ireland Trade Council. Recognize.
The chair recognizes the clerk again.
Mr. Speaker, after reviewing the bills assigned to Finance from last session, I see no fiscal notes with amendments on HBs 194 and 1294. Therefore, under House Rule 47F, I'd be allowed to waive off House Bill 194 and 1294. Thank you, Ken Weiler.
The House will be attentive to motions to suspend rules.
Mr. Speaker, Representative Shurtleff moves that all necessary House rules be so far suspended as to allow late drafting and introduction of a bill relative to requiring presence at a sentencing hearing of a Class A felony.
Representative Shurtleff is recognized to speak to his motion.
Thank you, Mr. Speaker. Mr. Speaker, I rise today to ask the House to suspend their rules, our rules, so that I can bring in a late bill. And Mr. Speaker, I'd like to answer three questions that this body may have. First being, what do I know now that I didn't know during the filing period? Secondly, what would the bill be about? And lastly, why this bill should be passed now and not taken up next year by the new legislature. Mr. Speaker, 4 years and 3 months ago, on December 7th, 2019, Adam Montgomery beat his little 5-year-old daughter, Harmony. But this time he beat the little girl for the last time and ended up killing her. Then, because the ground was frozen, he moved her body around to various locations. He kept her little body in an air shaft. He put it in a cooler, kept in a hallway. And then lastly, he kept it for the last month in a commercial freezer. When the ground had thawed, he finally disposed of her body. What I didn't know is under the state law, when a person is charged with a felony, they do not have to appear at their own trial. They don't have to appear at sentencing. And to me, this isn't right. When I think of the fact that the prosecutor is filing a motion after Adam Montgomery was found guilty last month to ask the court to compel him to be present for his May 9th sentencing. I said, this isn't right. And I could think about this horrendous crime, but I think about someone who was a victim of felonious sexual assault. And we have a very strong victim bill of rights in this state, where people have the right to either in writing or orally present to the court their victim statement. And I couldn't think of anything worse for someone who has been a victim of a crime to be presenting that statement to the court and look at the defense table and see an empty chair where the perpetrator of that crime should be sitting. Mr. Speaker, what I would like to bring in for a bill, and I would use the Federal Rules of Criminal Procedure, Rule 43, which is the federal rule that requires all people charged with a felony in federal court, regardless of the seriousness of the offense, to be there at their arraignment, jury selection, trial, and sentencing. What I would propose is not as stringent. I would propose in a bill that anyone charged in the granted state with a Class A felony, and in New Hampshire we have two classes of felony, Class B, where you can get 1.5 to 3 years incarceration, or a Class A, which carries a penalty of 7.5 to 15 years unless it's a capital offense, and then you're facing possible life. Class A felonies cover primarily our crimes of violence, from murder, rape, burglary, armed robbery, arson, felonious sexual assault, and the list goes on. My proposed bill would require that person to be in court during the judicial process. It would allow for either the defense or the prosecution to file a motion with the court based on just cause for the defendant to be absent, or on motion of the trial judge themselves. Again, I don't believe that it should be put off to next year. As I said, the prosecutors filed a motion with the court compelling Adam Montgomery to be in court to face Harmony's other family members and people that loved her. I don't know how the court is going to rule, but I ask you to grant me the permission and to bring in a late bill so that it can file this bill so that anybody charged with a Class A felony, like Adam Montgomery, will be in court. Thank you, Mr. Speaker.
The question is on the motion to suspend the rules, and this will be a division vote. Members, take your seats. The question is on the motion to suspend the rules, and this is a division vote.
Please turn on your voting station.
Members are reminded to turn on their voting stations. There we go. If you're in favor of suspending the rules, press the green button. Opposed, press the red. Voting stations are open for 30 seconds.
Representative Devine. Representative Devine. Representative Bucco. Thank you. Representative Phillips.
Have all members present had an opportunity to vote? The House will attend to the state of the vote. 286 in the affirmative, 67 in the negative. Having reached the two-thirds threshold, the motion is adopted. The House will now attend to the regular calendar. For what reason does a member rise? Okay.
There was a mistake with the voting in my row.
She can correct it.
The majority of the Committee on Children and Family Law, to which is referred CACR 17, an act relating to the rights of parents, providing that parents shall have a fundamental right to direct the upbringing, education, and care of their minor children. Having considered the same, report the same with the following resolution. Resolved that it is inexpedient to legislate. Representative Peter Petrigno for the majority of the committee. The minority of the committee, having considered the same and being unable to agree with the majority, report with the recommendation that the bill ought to pass. Representative Mark Pearson for the minority of the committee.
The debate is on ITL.
The motion is inexpedient to legislate. Representative Cordelli is recognized to speak against the motion.
Thank you, Mr. Speaker. There's a long history in this country about parents' rights. Let's start with the U.S. Supreme Court cases that date back almost 100 years. First one I'll mention is Pierce versus the Society of Sychterz from 1925. Let me quote from that decision. "The child is not a mere creature of the state. Those who nurture him and direct his destiny have the right, coupled with the high duty, to recognize and prepare him for additional obligations." Prince versus Commonwealth of Massachusetts from 1944. "It is cardinal with us that the custody and care and nurture of the child resides first with the parents." Just a couple of additional cases. 1972, Wisconsin versus Yoder. 1977, 1982, 1993, I'll mention this one. The 14th Amendment forbids the government to infringe on the fundamental liberty interests of all, no matter what process is provided, unless the infringement is narrowly tailored to serve a compelling government interest. We'll touch on that again. Washington versus Gillicksburg, 1997. Troxel versus Granville, 2000, and there are more. I won't go into all of them. But the rulings have been consistent that the Due Process Clause of the 14th Amendment of the United States Constitution protects the fundamental right of parents to direct the care, upbringing, and education of their children. CACR 17 adds an amendment to our Constitution's Bill of Rights right under the right of privacy that we passed and the public voted for in 2018. This amendment does three simple things, three simple sentences. First sentence, parents have a fundamental right and responsibility to direct the upbringing, education, and care of their children. And the argument against that is what? The Supreme Court has ruled and said that very same thing for years. The second sentence, neither the state nor any political subdivision shall infringe on these rights without demonstrating that its compelling governmental interest as applied to the person is of the highest order and not otherwise served. This parallels a Supreme Court case of Reno versus Flores, which upheld the 14th Amendment and said the same thing about compelling government interest. Third sentence, this article shall not be construed to apply to a parental action or decision that would end the life or otherwise physically harm a child. So it's not giving parental rights to parents to harm their children. Specifically, we are putting that in the amendment. So why is this amendment needed? Exhibit A, the majority report is Exhibit A, why this is needed. The majority report says that this may enable parents to do things like forcing children to quit school to go to work or neglecting the proper health care of their children. In effect, it may enable parents to be bad parents. Evidently, they did not read sentences 2 and 3 of the amendment that says specifically that parents are not allowed to cause harm based on this constitutional amendment. They are also ignoring the laws of New Hampshire that protect children. And there is Sandowski versus Kramer 1982 Supreme Court case about the minimal interests of the child which they might read. Additional attacks on parents have been heard in this chamber and in our committee, Education Committee, repeatedly. A few years ago, here in this very chamber, there was a bill related to homeschooling that attacked parents' rights who homeschool. It was said in this chamber that homeschool parents sometimes want to homeschool their children because they abuse their children, and this would hide the abuse. This week, we had 400 to 500 parents come to the Education Committee to talk about their rights and another attack on their rights. This is repeated. This is why we need this constitutional amendment in our Constitution. Please vote red to overturn this ITL motion because parents around the state are watching and they want to be able to vote on this, and they deserve a right to vote on this. Thank you.
Representative Patrigno is recognized to speak in support of the report.
Thank you, Mr. Speaker. Colleagues, the majority of the committee is opposed to this legislation, not because we are opposed to parental rights, because after all, we're parents and grandparents as well, and we cherish our rights no less than others, but because we know that parental rights already exist. They are well established in federal and state statutes. They have been affirmed time and time again in court rulings, and that this will not give parents anything more than what they already have. It has been repeatedly asked in committee hearings and personally to individual members, do parental rights already exist? And the answer is always yes. Likewise, will this legislation give parents anything more than what they already have? And the answer is no. We are doing our constituents a huge disservice when we put forth legislation which leads them to believe that they do not have parental rights or that we're going to bestow upon them rights which they don't know they already have. You see, it seems to me that the real issue is that some parents believe that their rights are being violated and that they want recourse. The question then is, how do we address violations of parental rights? And we don't solve that problem by simply restating the obvious, which is what this legislation does. Instead, we best serve our constituents by being honest with them and directing them accordingly. Additionally, while good parents, the vast majority, are already protected under existing laws and court rulings, the committee does fear that some, the few, may feel falsely emboldened to act in ways which are not in the best interest of their children and puts them in harm's way. Colleagues, I ask that you vote with the bipartisan committee recommendation of inexpedient to legislate. Thank you, Mr. Speaker.
The questions on the motion of inexpedient to legislate on CACR 17. This will be a division vote. Members, take your seats. Representative Sweeney requests a roll call. Is that sufficiently seconded? Yeah, it is. This will be a roll call vote. Members, still take your seats. The questions on the motion of inexpedient to legislate on CACR 17, and this is a roll call vote. Representative Mark Pearson is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. If I know that most parents are good parents, and that they are the ones who should have the primary role in their children's upbringing, and if I know that this amendment would not interfere in any way with DCYF and with the Office of the Child Advocate in their important roles of safeguarding the physical and psychological abuse in those cases where parents are not good parents. And finally, if I know that this amendment would balance the scales between the rights and responsibilities of the parents with the rights and responsibilities of the state, would I not now push the red button so that another motion may be brought forth? Thank you, Mr. Speaker.
Representative Long is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. If I know the House rejected 2 bills addressing like-minded issues last year, and if I know current statute enshrines rights of parents with respect to their children, then would I press the green button? Thank you, Mr. Speaker.
The question is on the motion of inexpedient to legislate on CACR 17, and this is a roll call vote. If you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds. Have all members present had an opportunity to vote? The House will attend to the state of the vote. 174 in the affirmative, 186 in the negative. The motion fails. Representative Mark Pearson moves ought to pass on CACR 17. The bill's on second reading and open to further amendment. Representative Hull moves floor amendment 1003H, which can be found in your seat pockets, and is recognized to speak to his motion.
Good morning, everybody. The amendment before you is simple. It's 1 line versus 3 in the original bill. It reads, "The fundamental right and responsibility of parents to direct the upbringing, education, health, and care of their minor children shall not be infringed." It's easy to make the argument that we need to put all of those additional constraints that's in the current bill into our Constitution. But we don't do that for other things. You can still be prohibited to own a firearm if you've committed some egregious act that turns into a felony or a misdemeanor with a penalty of greater than a year in jail. Doesn't say shall not be infringed with the exceptions of a bunch of different things. It says our fundamental rights for firearms shall not be infringed. Same thing here relative to parenting. Parents have the right to direct the education and welfare of their children. We know that. This amendment clearly states that. If a parent has done something so egregious that they need to have their parental rights terminated, that still can happen in statute. We don't need to put that extra clause into the Constitution. That will create long-term legal battles that we don't want. I would ask that you would adopt this amendment. Thank you.
The question's on the adoption of Amendment 1003H. Are you ready for the question? All those in favor say aye. Wait, hold up now.
You had a request for a division before.
All right, this will be a division vote. Members, take your seats. The question's on the adoption of Floor Amendment 1003H. This is a division vote. If you're in favor of adopting the amendment, press the green button. Opposed, press the red. Voting stations are open for 30 seconds.
Representative McKay.
Have all members present had an opportunity to vote? The House will attend to the state of the vote. 173 in the affirmative, 189 in the negative. The amendment fails. Now we're on to the motion of ought to pass on CACR 17, and this will also be a division vote, so let's just stay right where we are. The question is the motion of ought to pass on CACR 17, and it's a division vote. If you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds.
Representative Boschman.
Have all members present had an opportunity to vote? The House will attend to the state of the vote. 180 in the affirmative, 183 in the negative. The motion fails.
Okay. Bills on second reading open to further amendment. Utah offers for amendment and speech preference.
Got it. The Committee on Children and Family Law, to which was referred House Bill 1006 FN, an act relative to creating a family access motion for the enforcement of parenting plans. Having considered the same, report the same with the following amendment and the recommendation that the bill ought to pass with amendment. Representative Alicia Gregg for the committee. The committee amendment is 0448H, printed in House Record 9 on pages 46 to 47. The question's on the adoption of the amendment. Are you ready for the question? All those in favor say aye. Aye. All those opposed, nay. The ayes have it, and the amendment's adopted. The bill is on second reading and open to further amendment. Representative Kuchab offers floor amendment 0553H, which can be found in your seat pockets, and is recognized to speak to her motion.
Thank you, Mr. Speaker. The floor amendment just changes one piece that was missed. It was redlined and just missed by one of the drafting attorneys. It was a quick turnaround time thing. If you look in section 4, part A, where it says visitation, it was just changed to parenting time, and that's exactly how it should be. So this is one change, just changing visitation to parenting time, and I ask you to please support the floor amendment. Thank you.
The question is on the adoption of floor amendment 0553H. Are you ready for the question? All those in favor say aye. Aye. All those opposed, nay. The ayes have it, and the amendment's adopted. Now the question is the motion of ought to pass with amendments on House Bill 1006 FN. Are you ready for that question? All those in favor say aye. Aye. All those opposed, nay. The ayes have it, and the motion's adopted. The majority of the Committee on Children and Family Law, to which was referred House Bill 1189, an act relative to criteria for reporting child support delinquencies to federal agencies. Having considered the same, report the same with the following resolution: resolved that it is inexpedient to legislate. Representative Patrick Long for the majority of the committee. The minority of the committee, having considered the same and being unable to agree with the majority, report with the recommendation that the bill ought to pass. Representative Deborah D. Simone for the minority of the committee. Representative D. Simone is recognized to speak against the committee report.
Thank you, Mr. Speaker. Mr. Speaker, unfortunately, society is filled with parents who don't take the financial responsibility of their children. But there are more parents who do take the financial responsibility of those children seriously. House Bill 1189 was introduced to the Children and Family Law Committee for the simple reason that a state agency isn't doing the job they are tasked to do properly. We have many, many parents in this state who are working hard and voluntarily have their wages garnished to make sure that their children are supported financially in a proper manner. When the committee heard testimony, the New Hampshire Bureau of Child Support Services stated that it is tasked to accurately report all arrearages in child support over, I repeat, over $2,500 to the federal government. And that they do. What they don't do is report the fact that someone has paid those arrearages and is no longer in arrears, or the arrearage is well under the $2,500 mark and could be as low as $5. Such was the case of the sponsor of this bill. The committee heard testimony from the New Hampshire Bureau of Child Support Services concerning their reporting process, but when asked how many people this action affected, the answer was, ready? We don't currently have that information. When asked if they could get that information, the answer was, I'm not really sure. So this testimony led to some committee members believing that this bill was brought before us because one person's issue. Therefore, they felt the need to ITL this bill, stating that they were not going to legislate for just one person. Okay. I and other members of the committee found it very hard to believe that that could be the case, that it was only one. So one committee member came to me and said, can we file a 91A? We talked about it for a while and then thought, we have a very able committee researcher. Why don't we ask her to do the research? And our committee researcher, as able as she is, did. So the following information that I'm going to read to you was not available to our committee at the time that we execed this bill. It's a memorandum. The subject was individuals reported for child support arrears in the last 24 months. Question: how many individuals in the last 24 months have been reported to the feds because they met or exceeded $2,500 in child support arrears threshold? Here's the staggering number: 12,087 parents. I guess it's more than one. The second question was, how many individuals continue to be reported to the Fed after falling below the $2,500 in arrears threshold, but not at zero owed? So to determine this number, they compared the total number of individuals, 12,087, to the federal collections debtor file on 1/31/24, the total number of individuals who continued to be reported and whose arrearages fell below the $2,500, which meant that they owed somewhere between $1 and $2,499, but not zero, is 1,037 people. That's not one person either, is it? I do understand that the committee did not have this information at the time that we execed the bill. So I think you can agree that these numbers are staggering, shocking, and personally, I find it appalling that these many people have been denied passports, listed as deadbeat parents, when they're really not. Because what happens is, if you get paid every 2 weeks or once a month, inevitably you will be behind at some point during the year because of how many weeks there are per month. It's not your fault. You have voluntarily had your wages garnished. The state is collecting that money for every pay period. You're not voluntarily refusing to pay child support. So, ladies and gentlemen, I ask you to vote no on the ITL motion so that another motion can be brought forward. Thank you.
Representative Grossman is recognized to speak for the committee report.
Thank you, Mr. Speaker. Good morning, fellow representatives. HB 1189, relative to criteria to reporting child support delinquencies to federal agencies, is recommended inexpedient to legislate after numerous discussions based on the testimony of one representative that tried to leave the country but was denied because he came up on the federal list for having an arrearage of $2,500, the federal threshold for past due child support, which triggers a passport denial. Yes, the Bureau of Child Support notifies you. It is up to individual responsibility of the payee to follow up once they've been notified of their upcoming passport denial notice because of the past due child support over $2,500. It is up to the individual to work with the Bureau to remove their name from the federal passport program once the file is submitted and notification is received of their failure to pay. We heard testimony from the Bureau of Child Support that informed us that caseworkers are trained to pick up nuances of timing with payment obligations. There already is an automated system in place. This legislation would require an adjustment to the automated federal reporting system, which would require a financial appropriation which is not included in this bill. This would also place us in jeopardy of non-compliance with the federal requirements. It's important that we remember that we are talking about the welfare and care of children and the parental obligations we have when we bring children into this world. Please support the motion of inexpedient to legislate, vote green, and let's move on because we are not here to legislate for our personal gains. We are here for the people of New Hampshire. Thank you, Mr. Speaker.
The question is on the motion of inexpedient to legislate on House Bill 1189. This will be a division vote. Members, take your seats. The question is on the motion of inexpedient to legislate on House Bill 1189, and this is a division vote. Representative Spillane is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. Members, if I know that there was a will by the chair of the committee to recommit this to committee, but that the time frame that we're allowed now does not allow so because of the need to move things to the other body, and if I further know that if we pass this today and overturn the ITL, that the other body will be able to fully vet this in a public hearing with the new information that was brought with well over 1,000 people who have been denied passports when they never exceeded that $2,500 threshold because their pay periods lined up improperly with the weekly pay that's required by the department. And if I further know that much of the misinformation you heard in the testimony from the ITL side of things is simply that, misinformation, and doesn't take the facts of the cases into play, would I now push the red button to overturn the ITL so that an appropriate motion could be made and this could be heard in the other body? Thank you.
Representative Long is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if I know New Hampshire's automated reporting system reports arrearage at 2,500 and above, and if I know that reporting is done once and it is up to the person in arrearage to straighten that out with them so they wouldn't be continually reported, and if I further know that House Bill 1189 would require additional expense in updating our system, then would I press the green button and support the bipartisan committee report?
The question is on the motion of inexpedient to legislate on House Bill 1189, and this is a division vote. If you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds.
Representative Bay.
Have all members present had an opportunity to vote? The House will attend to the state of the vote. 174 in the affirmative, 191 in the negative. The motion fails. Representative DeSimone moves ought to pass. Are you ready for the question? All those in favor say aye. Aye. All those opposed, nay. Nay. The ayes have it, and the motion is adopted. The Committee on Children and Family Law, to which is referred House Bill 1263 FN, an act relative to parenting coordinators in high conflict cases. Having considered the same, report the same with the following amendment and the recommendation that the bill ought to pass with amendment. Representative Patrick Long for the committee. The amendment is 0476H, printed in House Record 9 on page 62. The question's on the adoption of the amendment. Are you ready for the question? All those in favor say aye. Aye. All those opposed, nay. The ayes have it, and the amendment's adopted. Now the motion is ought to pass with amendment on House Bill 1263. Are you ready for the question? All those in favor say aye. Aye. All those opposed, nay. The ayes have it, and the motion's adopted.
There's a request for a roll call.
Got it. The Committee on Children and Family Law, to which was referred House Bill 1266 FN, an act relative to permitting recordings of open family court proceedings by parties. Having considered the same, report the same with the recommendation that the bill ought to pass. Representative Lori Ball for the committee. Representative Long is recognized to speak against the committee report.
Thank you, Mr. Speaker. House Bill 1266 allows recordings of open family court proceedings by parties involved. On its face, very reasonable. It's limited to involved parties only. Would recording be from the table where each party sits? Would the court deem that disruptive? It was stated in the testimony that someone else could record for a party. This bill has no mention of that. Would the party recording need to move from their front table and addressing their devices if the judge allowed it to be in the back of the court? Is that disruptive? Private communications are not to be recorded. Who would verify that? The front of the judges' benches today, audio capabilities easily pick up the audio. Also, audio on private conversations with opposing party can and would be also picked up. Finally, change of custody. For personal pro se, it's not a problem to review their own video and audio and helping them with their case. However, if needed to be entered in the record, as we heard in testimony, how would the chain of custody be determined? Currently, with the court's permission of recordings, can be done by anyone. A party in a proceeding can invite someone they know to record, allowing for concentration on their proceedings with the court approval. The minority believes House Bill 1266 would create additional conflict between the parties and the court. And Mr. Speaker, I request a division vote.
Representative Ball is recognized to speak for the committee report.
Thank you, Mr. Speaker. This bill will allow parties to record proceedings that are open to the public in Family Division of the Circuit Court. These proceedings are already recorded by the court and are available to the public for a fee. So there is no concerns about privacy. Sometimes the court's recordings of the proceedings fails to record or stops partway through the hearing. In circumstances such as this, having a recording available is extremely helpful, especially to those who do not have an attorney and need to play back the hearing to better understand the outcome of the proceedings when they had difficulty understanding the proceedings while they were happening. This bill is narrowly tailored to meet the same requirements the court is currently following, except that it would not require notice of intent to record prior to the hearing. The bill prohibits the recording of private communication of others, including bench and sidebar conferences, conferences between counsel, and conferences between counsel and client. Please help those who cannot hire an attorney and find themselves in family court by pressing the green button. Thank you.
The questions on the motion about to pass on House Bill 1266. Representative Granger requests a roll call. Is that sufficiently seconded? It is sufficiently seconded. This will be a roll call vote. Members, take your seats. Quick housekeeping note. Members are reminded that when someone's speaking at the well, avoid coming down the aisle, and for sure, don't stop at the bottom of that aisle to have a conversation in front of the people who are speaking. This is a roll call vote on House Bill 1266. The motion is ought to pass. Representative Grossman is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. If I know recordings are already permitted in court with prior permission, therefore this legislation is unnecessary. If I also know that this raises privacy issues for children, if I know that this bill would raise concerns about how the Supreme Court will decide which recording to rely upon in appealed cases, and finally, if I know that New Hampshire Legal Assistance, the New Hampshire Coalition Against Domestic Violence and Sexual Violence, and Waypoint all gave us testimony against this, please vote no on HB 1266 so that another motion can be made. Thank you.
Representative DeSimone is recognized for parliamentary inquiry.
Mr. Speaker, thank you very much for this opportunity. If I know that the previous speaker is correct, with prior request, you can absolutely record the proceedings. But if I know that in some cases people don't have the time, nor are they aware that they can make that previous request, and if I know that it is humanly impossible to remember everything that is said in a courtroom, especially if you're nervous or upset. And if I finally know that it is very important for all people to have access to what is said about them and to them in a court of law, then I would ask you to press the green button and pass this very important legislation.
The question's on the motion of ought to pass on House Bill 1266, and this is a roll call vote. If you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds. Have all members present had an opportunity to vote? The House will attend to the state of the vote. 191 in the affirmative, 173 in the negative. The motion's adopted. The majority of the Committee on Children and Family Law, to which was referred House Bill 1308, an act relative to parent access to children's library records. Having considered the same, report the same with the following resolution. Resolved that it is inexpedient to legislate. Representative Heather Raymond for the majority of the committee. The minority of the committee, having considered the same and being unable to agree with the majority, report with the following amendment and the recommendation that the bill ought to pass with amendment. Representative Sandra Panic for the minority of the committee. The questions on the motion of inexpedient to legislate. Representative Quartiello is recognized to speak against the motion.
Thank you, Mr. Speaker. The purpose of HB 1308 is to allow parents to know what library books their children have checked out at both public and school libraries. Currently, library circulation records are considered confidential for all users, including minors. The problem with this law is reflected in a common situation at library circulation desks in which a parent pays an overdue fine on a child's account, but the library staff member cannot tell the parent what book the fine is for. Aside from practical problems with this law, there is a more fundamental issue that reveals its inconsistency. The American Library Association asserts on its website that, quote, the parent's role is to monitor his or her child's individual reading life, end quote. To fulfill their parental role more effectively, parents need to know what books their children have checked out. This is especially important in school libraries where parents are not usually present with their children, as they often are in public libraries. While some children may not want their parents to know what they are reading, their privacy rights should not extend to their use of materials that they have not financially contributed to. Parents should be able to access their child's library records because as adults, they are the taxpayers who fund their school and public libraries. Meanwhile, this bill does nothing to a child's right to privately read whatever they want inside the library. HB 1308 has been criticized as an unfunded mandate. This bill does require a library to share all library records regarding a child's use of material. If a library, however, doesn't keep comprehensive records of every book ever checked out by patrons, all library records would just refer to the current books that are checked out by the child. This bill would not require them to change this policy. There is no cost incurred to simply show a parent these existing records. Regarding this issue, I do have a simple clarifying language to propose if this ITL is overturned, and I am able to offer a floor amendment. Another objection to this bill in committee was that it would put a child in danger of parental abuse. In order to implement this law in the best interest of the child's safety, a library could mitigate such a threat by having a policy of asking for the parent's driver's license and making sure the address matches that on a child's account. It should also be emphasized, however, that library staff are not the police. It should be on the onus of the custodial parent to bring any concerns about a potentially abusive parent to the attention of library staff, just as they would inform schools and teachers of such a situation. Again, the floor amendment I will offer, if the ITL is overturned, addresses this issue. And also remember that this language could be further clarified on the other side of the wall. In conclusion, to improve library service and support parental involvement in their children's reading pursuits, please vote no on the ITL motion so that another motion may be made. Thank you, Mr. Speaker, and I request a division vote.
Representative Raymond is recognized to speak for the committee report.
Thank you, Mr. Speaker. A bipartisan majority of the committee felt that this bill was not practical and recommended an expedient to legislate. Here are a few reasons why. Currently, most libraries in New Hampshire and most libraries in the United States do not keep lists of the books patrons have checked out for longer than 30 to 90 days. These records are used only for the purposes of assigning late fines and are typically purged once the book is returned. Libraries do have a catalog of materials for collection maintenance, but it doesn't include identifying information of readers for any particular book. So if you or I wanted to get a list of all the books that we personally checked out last year, we would find that it doesn't exist. There are currently no libraries in New Hampshire that create or maintain records of visitors' internet history, nor records of visitors' participation in activities and events happening at the library. This bill would require libraries to create a recording system for the activities and information, to that type of activity and information. In order to do that, our libraries will have to invest in new databases and hire additional staff at an unknown cost to local property taxpayers. It's important to note that libraries don't collect this data because of the First and Fourth Amendment, the Privacy Act of 1974, and the 1998 Children's Online Privacy Protection Act. There are several U.S. Supreme Court cases that affirm the right to privacy when accessing public libraries. The other concern of the committee was that this bill can be dangerous to abused and neglected children and victims of domestic violence. It's common for the family court to issue protective orders and restrictions on access to records as part of a custody agreement in cases where there has been abuse, neglect, or domestic violence. By requiring libraries to give information to any parent without knowledge of custody orders, it creates a gateway for abusive people to access information that the court has determined they are not legally entitled to. Libraries are public facilities. They should not be put in the middle of custody and parenting plans. Lastly, it's important to recognize that libraries are public buildings, not babysitting services. One of the most fundamental responsibilities of parenting is to meaningfully connect with one's children and guide them to developmentally appropriate activities, media, and reading choices that align with their own family values. Parents who feel genuine concern about their children being exposed to developmentally inappropriate materials should be providing parenting supervision while in the library. Parents who are concerned that their older children are not responsible enough to choose materials that align with their family values already have the option of simply not giving their child their own library card and instead have them use the parent's library card, something to which the parent has unfettered access. For all of these reasons, I urge you to concur with the bipartisan supermajority of the committee and press green to keep the ITL.
Does the member yield for a question?
I do not yield.
The questions on the motion have been expedient to legislate on House Bill 1308. Representative Granger requests a roll call. Is that sufficiently seconded? That is sufficiently seconded. This will be a roll call vote. Members, take your seats. Questions on the motion of inexpedient to legislate on House Bill 1308, and this is a roll call vote. Representative Drago is recognized for a parliamentary inquiry.
Thank you, Mr. Speaker. If I know that libraries already keep track of who takes out a book, and by adding one more person on the record to know who can take out a book does not create an unfunded mandate, and if I know children at the age of 6 and in some cases 5 are allowed to have a library card, and from that moment on, parents do not have access to what their child reads in record, and if I know a parent is responsible for their child's overdue or lost book fines, but they can't be told what book they are actually paying for, and if I know that at the moment an individual makes a life choice to start a family, it's their right and their right alone to raise a child how they see fit, and it's not a government organization that can tell them, then you will join me in pressing the red button so another motion and an amendment can be introduced.
Representative Gregg recognized for parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if I know that this bill lacks the understanding of our library's current abilities and funding for record keeping, and if I know that the cost of making the necessary adjustments would be a great cost to taxpayers, and if I know that it should not be put on the librarians to police records access for complex family dynamics, and if I further know that parents are able to and strongly encouraged by our libraries to accompany their minor children in using the resources, therefore being able to help guide and observe their own children's choices, would I not support the overwhelming bipartisan committee opinion on this bill and press the green button?
Members are reminded to be in your seats or in the voting mode. The questions on the motion of inexpedient to legislate on House Bill 1308, and this is a roll call vote. If you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds.
Representative Schmidt.
Have all members present had an opportunity to vote? The House will attend to the state of the vote. 194 in the affirmative, 170 in the negative. The report's adopted. The majority of the Committee on Children and Family Law, to which was referred House Bill 1392, an act relative to consideration of the opinion of the child in determining parenting time. Having considered the same, report the same with the following resolution: resolved that it is inexpedient to legislate. Representative Patrick Long for the majority of the committee. The minority of the committee, having considered the same and being unable to agree with the majority, report with the recommendation that the bill ought to pass. Representative Candace Gibbons for the minority of the committee. Representative Gibbons is recognized to speak against the committee report.
Thank you, Mr. Speaker. This bill I came up with over the summer because I was going on a rabbit hole down the internet and I was doing some research. So it's true that we do already have in statute that the child can testify as far as what their opinion is regarding parenting time. But we don't actually see that in practice. So I started going down this rabbit hole to see why are we not seeing this in practice. And I was looking at PubMed, I was looking at law journals, and what I found out was that it is considered traumatic for a child to be brought into court and stressful for them. And so that's when I started doing the research to come up with this bill. So if it's considered traumatic to bring a child in to testify, and then the judge determines that the child is not mature enough to give their opinion, then basically the child was brought in, created some trauma, and then never had the opportunity to give their testimony. So I was like, well, I understand that. That makes sense to me. So how can we fix this? So usually what they do is in situations where the child's testimony wants to be brought into the courtroom, usually they use someone like a guardian ad litem. Well, the problem is that those are not funded by the state. And that's a separate issue, and if I'm reelected, then I can put in a bill that we can get funding for guardians ad litem through the state. So basically what we end up with is people who can afford a guardian ad litem have a guardian ad litem who can speak on behalf of their child. People who do not have a guardian ad litem or cannot afford one, their child doesn't get to speak. So again, I'm not really just looking for problems, I'm looking for solutions. So how can we fix this? Well, if the child has a therapist, then the therapist can just write a little blurb about, is the child able to testify? Is the child mature enough to testify? If they do that, then we don't have to bring in the child for the judge to do the assessment piece. We will bring in the report from the therapist telling the judge that yes, the child has the maturity to be able to give their opinion in court. And as a side note, I am a fan of equal parenting time. So this isn't so much for the child to say like what parent they want to live with. It's not about that. It's about, Billy has Fridays that he wants to go to Steve's house that lives near Dad, and so he wants to spend Fridays with his dad. But he'll still want, equal parenting time with his mom, so he might want other days with his mom. But it's the child's life. So I think that the child should be able to give their opinion about how they want the 50-50 parenting to look, because there's so many permutations on how 50-50 parenting time can be exactly crafted. So if we were to have the child assessed by a therapist to say that they're mature enough to testify in court, then we take that assessment piece off of the judge. The judge can affirm the child is mature enough to testify. They don't have to create any trauma on behalf of, traumatizing the child by bringing them in when they don't have any gain. You're only bringing the child in if you can get their opinion. I hope that makes sense. I would ask for you to vote red against the ITL. And I did present an amendment, which we can do next, to fix some of the language. Thank you, Mr. Speaker.
Representative Long is recognized to speak for the committee report.
Thank you, Mr. Speaker. I guess we don't need family court. It's a child's life. Let the child figure out what parent he wants to be with and when. House Bill 1392 will require that the court give consideration of a therapist, shall give consideration of a therapist to the child's report as to the child's sufficient maturity to make sound judgment. What's that relationship with the child and the therapist? Is it a report from a single session? Did the parent seek out a therapist that would benefit their outcome? This bill doesn't qualify that. Currently, a court can determine to interview the child. The court may interview the child. This bill adds, with the consent of the parties, that the majority is of the opinion that this takes the discretion of the court away by asking two parents that can agree to agree and allow an interview with the judge, simply creating more conflict. Finally, we have two adults that are unable to agree on parenting time, so allows the child to make that decision. I ask that you support. I ask you. I don't remember what this was. I ask that you support the ITL. Thank you.
The question's on the motion of inexpedient to legislate on House Bill 1392. Are you ready for the question? All those in favor say aye. Aye. All those opposed, nay. We're gonna, yeah. No, whoa, stop coming in. Everybody back out.
People that were not in the room when the question was.
Only people in the room when the question was put can vote. You folks know where you were? As a clarification, division vote, so nobody comes in. Hey. Okay. This is a division vote for the purposes of clarifying the voice vote. If members should take their seats. If you're in favor of an expedient to legislate, press the green button. Opposed, press the red. Voting stations are open for 30 seconds. Have all members present had an opportunity to vote again? The House will attend to the state of the vote. 219 in the affirmative, and the few, the proud, the nays at 121. The motion's adopted. Oh, no. The majority of the Committee on Criminal Justice and Public Safety, to which was referred House Bill 1527 FN, an act relative to criminal trespass, having considered the same, report the same with the following resolution: resolved that it is inexpedient to legislate. Representative Jason Janvin for the majority of the committee. The minority of the committee, having considered the same and being unable to agree with the majority, report with the recommendation that the bill ought to pass. Representative Amanda Bolden for the minority of the committee. Well then, Representative Phillips is recognized to speak against the committee report.
Thank you, Mr. Speaker. I see this bill as a liberty bill, property rights and all of that. I'm a sponsor. I think we should make it as easy as possible for people to post their land, no trespass, and other states have adopted a purple paint flare on trees to mark that as such. This bill would inform hunters every year when you get your license of the rules, and if the purple paint was adopted, that would be clear to them. This bill would not change people using the original signs to post their land to allow for cross-country skiers or other recreational activities, or allowing people to hunt, whatever they want to do, they could still use the signs. This bill also has a phase-in of 1 year that if it were to be adopted, we would still need to use the signage for the 1 year until we inform the public of the change. I believe that this is not an anti-hunter bill, which is what some people are saying this is. This is a property rights bill, and I'm just trying to make it easier for elderly property owners to maintain and post their land by using a can of spray paint that Krylon already prints, it's purple, and marking their trees as such if they want a no trespass on their land. I think that the public is smart enough to figure it out once it's employed here, just like it is in other states, and I have no problem supporting this. It's a liberty bill. Please vote against ITL so that another motion can be made. Thank you.
Representative Potenza is recognized to speak against the report.
There are a lot of people in here that hate the hypocrisy we see quite frequently in arguing for or against legislation in this chamber and in our committees. That is the reason why I'm speaking to overturn the ITL. So the majority of arguments that I've heard from my side of the aisle are about bad actors that will mark people's private property. Those same bad actors can easily post signs too. So do we infringe on the Second Amendment and take law-abiding citizens' firearms because of bad actors? No. The gun doesn't operate on its own, and neither does the paint can. So if you research purple paint laws, you will find the majority of the states that have these in place lean conservative. A Republican helped draft this bill, and it actually does have some bipartisan support. So I stand with property owners having options. This bill allows property owners to mark their property with no trespass paint or signs. It doesn't require anybody to do anything. It gives people options. So if we're going to uphold the constitutional principles for the rights of gun owners, then property owners deserve the same. Part 1, Article 2, natural rights. We all have the right. Essential inherent rights are enjoying and defending life and liberty, acquiring and possessing and protecting property. So I'm going to just read one quote and I'll be done. This law, this is from someone that's in a very conservative state, isn't just in place to keep landowners and their cattle safe. It also assists busy farmers who cannot keep an eye on their land borders. Farmers can easily mark trees around their land in a cost-effective way rather than taking time and money to invest in property signs that may not last very long. Please vote red against the ITL for another motion to be presented. Thank you.
Representative Muse is recognized to speak against the report.
Thank you, Mr. Speaker. I guess you could sum up my remarks basically by just saying what she said and what she said. Our committee has heard variations of this bill for the past couple of sessions. In the online testimony submission system, we had 60 people who signed in support of this bill and 16 who signed in against it. And I know a lot of folks in this room, I'm not one of them, I represent a city, but I know a lot of the folks in this body represent towns. And so when I actually looked at where the people were from who were signing in support of this bill, I'm not seeing towns like Manchester and Nashua and Portsmouth. What I am seeing are towns like Stoddard, Benton, Dalton, Auburn, Deering, Claremont, Newton, Webster, New Boston, Alton. I could go on. This is a bill that your constituents want. Another thing I would just remind everyone of is I know this has been framed as a property rights bill, but in many ways, this is also a bill that's about privacy. We've actually, in this body, we think so much of the right of privacy, we've actually enshrined it in our state constitution. This is a bill that simply would allow more people to exercise that right in a way that works for them. Thank you.
Representative Roy is recognized to speak for the committee report.
Thank you, Mr. Speaker. I really got tag teamed on that one. So here's the concept. Everything everyone said is mostly true. It will make it easier to post your land. Although Fish and Game testified in front of our committee that if you want your property posted, they'll come out and do it for you. Why would they do such a thing? So that they can help maintain the deer herd. They want good relations with hunters. Fish and Game was against this bill. Now, in all honesty, I'm the one who actually helped write the bill a year ago because I thought it was a good idea when I heard it. However, like many ideas, once you research it more and more, you learn more about it. So the question is, put aside the hunting and the rights and the trespassing. Let's get down to our fundamental, what we believe as a state. This state, in the 1600s when we founded it and populated it, came from England, where if you killed a deer that was on the king's land, you were executed. It was the king's property. He didn't care if your children were starving. If you went and tried to trespass on his land and collected animals to feed your family, you were executed. So our founders said, we're not going to do that anymore. We're going to share this land. So New Hampshire was founded on a concept of shared land. It doesn't mean you can't post your property, but they did make it so you had to take an extra step to do so, so that the initial implication was, barring everything else, you were going to share your land. So what this bill will do, it makes haves and haves not. If you don't own land and you can't find somewhere without purple paint, you can't hunt. So most of the hunters in the state actually don't own land. So what you're doing is you're eliminating this for people who don't own property. So we hear this, we're supposed to be a free state, but we hear a lot of people saying, well, it's my property, not in my backyard. I'm going to paint it, you stay away. Is that what we stand for as a state? Because that's really what this bill is about. Are we still a state that we value sharing with our neighbors the great outdoors of this state? Or are we going to put up walls and borders and protect our own little fiefdom and no one else can come in? So I ask you to think about that when you cast this vote. Do you want to change the culture of this state from one that was founded on sharing the land to one that's just for me and nobody else? I would ask you to support the ITL. Thank you.
Does the member yield for a question?
The member does not.
The question is on the motion of inexpedient to legislate on House Bill 1527, and a division vote has been requested. Members, take your seats. The questions on the committee report of inexpedient to legislate on House Bill 1527, and this is a division vote. Representative Harriet Gathright recognized for parliamentary inquiry.
Mr. Speaker, if I know Not one landowner appeared in opposition to HB 1527, wherein in the past, before the changes, they filled the criminal justice public safety seats hearings against purple paints. Mr. Speaker, if I know, I have never voted for purple paint in the previous years because of the testimony of the owners. However, today, I like the idea that the owners have the option. They do too. And Mr. Speaker, and since I know that this bill is not mandatory, and the owners have the options to use the signs or the purple paint, as well as both, I would vote against the ITL motion so that another motion is offered. Thank you, Mr. Speaker.
Representative Rhodes is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if I know, we don't have to have the public to show up to tell us that a bill is bad. And Mr. Speaker, if I know that the citizens of New Hampshire have always felt that the land of New Hampshire was majestic and therefore it should be shared, and that if I know if a person is having any difficulty posting their land, or if they don't want to share their land at all, they don't have to, and Fish and Game will come help them post it. And if I know, Mr. Speaker, that the last 2 Farm Bureau meetings that the legislators were invited to in Cheshire County, that they expressed their exquisite opposition to this bill, would I now press green to vote with the committee?
The questions on the committee report of any expedient to legislate on House Bill 1527, and this is a division vote. If you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds. Have all members present had an opportunity to vote? The House will attend to the state of the vote. 202 in the affirmative, 161 in the negative. The report's adopted.
So this is without recommendation. Tanner moves on to pass and offers amendment 0666. Debate on the amendment. Debate on the bill.
The Committee on Education, to which was referred House Bill 1437, relative to the membership of the State Board of Education. The bill comes to us without recommendation. Representative Tanner moves out to pass and offers Amendment 0666H, printed on House Record 9 on page 67. The question's on the adoption of the amendment. You ready for the question? All those in favor say aye. Aye. All those opposed, nay. No. Lock the doors. I need to know who. We're going to do a division vote to clarify that. Members, take your seats. Okay. The question's on the adoption of Amendment 066H. If you're in favor of the amendment, press the green button. Opposed, press the red. Voting stations are open for 30 seconds. Or not. Yep.
Representative Lovett. Representative Roy and Rhodes. Representative Peterson. Representative McAleer.
Have all members present had an opportunity to vote? Good example of why being in the room is important. The House will attend to the state of the vote. 178 in the affirmative, 176 in the negative. The amendment's adopted. Now we are on ought to pass as amended on House Bill 1437. Representative Belcher is recognized to speak against the motion.
Thank you, Mr. Speaker. Good morning, colleagues. There's really 3 points you need to understand about this bill, and I won't belabor them. The first point is we heard testimony in committee that when this Board of Education was established, it was purposely meant to put everyday regular New Hampshire citizens in a regulatory and oversight role of education. This would put professional educators for the first time on this board. Second point, it's generally considered unethical and bad practice, not best practice, to allow people who are professionally involved in an organization or in a field to regulate what they are involved with. We don't put bankers in charge of regulating bankers, or at least we shouldn't. We don't put healthcare professionals who are active in the field involved with regulating themselves. It's not a best practice. The third and final point I will make, and this I think really says quite a bit, if I can paraphrase what we received in executive testimony from the ranking minority member of the committee who put it very bluntly. He said, the Board of Education, as it currently exists, is far right. And this bill is necessary to bring it to the left. Please oppose this. Vote no. Thank you. I request a roll call, Speaker.
Representative Chan is recognized to speak in support of the motion.
Thank you, Mr. Speaker. HB 1437 is a bill that modernizes the State Board of Education that was formed in 1919 to meet the demands of our present-day educational system. In 1919, the legislature and the governor realized in order to cherish education as directed in our Constitution, the education system of that time needed to make some drastic changes. The system needed to expand from the urban areas into the rural areas, and the state needed to take the lead in providing educational guidance and oversight of standards and programs to bring all children an opportunity of an education and an educated citizenry. In response to the the position of Commissioner of Education, along with the State Board of Education, to act as a Board of Trustees was created. The newly formed Commissioner of Education required a person with training and experience in educational work, and the board would complement this executive position and be comprised of 5 citizens from diverse backgrounds. Further, there would be no more than 3 of the 5 members on one party, and no technical educator or persons professionally engaged in schoolwork could serve. The composition and duties of the New Hampshire State School Board have
changed several times over the past 125 years, eliminating some of the regulations and duties while expanding others and increasing the membership to 7 by adding 2 at-large members. In HB 1437 addresses the need for changes in the composition of the State Board of Education that now has a tremendously expanded responsibility for decisions of today's state education system. Currently, the board oversees roughly 295 private schools serving 28,000 students, 495 public schools serving about 169,000 students, 4,700 EFA students, with 13,500 certified teachers plus administrators and staff. Today's State Board of Education deals with complex issues like academic and minimum standards, teachers' certification and training, building aid, charter schools, remote learning, extended learning opportunities, funding for special education, adequacy, credentialing, and the state's obligation in school funding, just to name a few. They are responsible for regular reviews and reports for all the programs and activities of the Department of Education. They advise the Commissioner regarding departmental goals, information gathering, and other aspects of elementary and secondary education. They are charged with hearing appeals and issues, making final decisions on rules made by the department, adjudicating any disputes between individuals and schools or the Department of Education, approving charter schools, and many other responsibilities. The issues in education at all levels have increased tremendously. The educational system has become more complex and requires a great deal of attention, input, and experience from a wide range of areas. Presently, there are 7 positions on the State Board of Education. The 5 positions are designated one each to each executive council position, and they were in the original membership in 1990. The current board also has 2 members that serve at large. Our surrounding New England states have expanded their membership of their boards of education to provide enough coverage for all these responsibilities and allow for formation of subcommittees for studies and reports. These New England states have also included more diversity by including stakeholders like parents, healthcare professionals, educational leaders from colleges and universities, students, as well as members of the educational system. HB 1437 seeks to increase the board to 11 members with 1 non-voting student member as well. The current membership of the 5 members, 1 from each executive council district and the 2 at large, will remain as stated. But the amended part will be the proposed new membership, which will include a retired public school classroom teacher, 2 parents of public school students, 1 member from the New Hampshire Administrators Association, and a student who serves in a non-voting position. The bill removes the restriction of not allowing anyone who is a technical educator to serve. On boards of other professional organizations such as doctors do serve on those boards. These major changes allow input from stakeholders who will bring their insight, experience, and knowledge to the State Board of Education to better represent and be responsive to a cross-section of all New Hampshire citizens who are interested and involved in our educational system. These changes will bring our State Board of Education new input and energy needed to meet all the many responsibility and will provide guidance and advice to prepare New Hampshire students for their future and to meet the challenges of the 21st century and beyond. I urge you to vote ought to pass, and I ask for a division vote. Thank you.
Does the member yield for a question?
No, I do not.
The member does not yield. The questions on the motion of ought to pass is amended in House Bill 1437. Representative Belcher requests a roll call vote. Is that sufficiently seconded? Yep, as sufficiently seconded. This will be a roll call vote. Members, take your seats. questions on the motion of ought to pass as amended on House Bill 1437? Representative Ladd is recognized for parliamentary inquiry.
Thank you very much, Mr. Speaker. If I know this bill will upend the historical intent and the balanced membership of our State Board of Education, if I also know it would place professional educators, administrators on that state board in conflict with an opinion of the justices written in 1973 that states, and I will quote, "Members of the Board of Education shall not be professionally engaged in school work." And if I further believe this bill will result in total conflicts of interest on the state board, would I then keep the state board in its present composition of 7 state board members by pressing the green button to ITL this bill? Hey, yeah, sorry, red. Red button.
That's why we ask. Representative Damon's recognized for parliamentary inquiry.
Thank you, Mr. Speaker. If I know that the roles and responsibilities of the State Board of Education have a broad impact on our education systems and quality, and if I know that HB 1437 creates a much more informed board membership by including members with direct knowledge and experience in our schools, but maintains a majority of non-educator members, and if I know that the chair of House Education routinely respects and refers to educators for testimony in our committee, and if I know that a strong education system is essential to the well-being of our society, would I now press the green button? Thank you.
The questions on the motion of ought to pass as amended on House Bill 1437, and this is a roll call vote. If you're in favor, press the green button. Opposed, press the red. Voting stations are open, hopefully for 30 seconds. Have all members present had an opportunity to vote? The House will attend to the state of the vote. 176 in the affirmative, 190 in the negative. The motion fails. For what reason does the member rise?
I move indefinitely postpone House Bill 1437.
Representative Sweeney moves to indefinitely postpone House Bill 1437. Are you ready for the question? Yeah, I thought so. This will be a division vote. Members should already be in your seats. All righty. If you're in favor of indefinitely postponing, press the green button. Opposed, press the red. Voting stations are open for 30 seconds.
Representative Gilman. Representative Cloutier. I can't see your hand. Thank you.
Of all members present and an opportunity to vote, the House will attend to the state of the vote. 193 in the affirmative, 173 in the negative. Indefinite postpone passes. The Committee on Education wishes to refer to House Bill 1695 relative to the release of student personally identifiable information comes to us without recommendation. Representative Cordelli moves ought to pass and offers Amendment 0641H, printed in House Record 9 on page 70. The question's on the adoption of the amendment. Are you ready for the question? All those in favor say aye. Aye. All those opposed, nay. The ayes have it, and the amendment's adopted. Now the motion is ought to pass as amended on House Bill 1695. Representative Balboni is recognized to speak against the motion.
Thank you, Mr. Speaker. HB 1695 concerns a very important issue: student privacy and the protection of student personally identifiable information. Clearly, maintaining student privacy is of the utmost importance, and school districts are required to follow state and federal laws designed to protect this information, as well as ensure that any contracted providers comply with New Hampshire student data privacy regulations. Usage of personally identifiable information already requires parental consent and is heavily regulated through the Family Educational Rights and Privacy Act, New Hampshire RSAs, and the Department of Education minimum standards for privacy and security of student and employee data. Further, school districts participate in the New Hampshire Data Privacy Consortium and only work with vendors who can meet the standards for maintaining data privacy. Each year, school districts provide parents with information about federal, state, and school district policies and procedures. And parents must sign a notice acknowledging receipt of this information. Parents have the opportunity to opt out of sharing even minimal directory information. Additionally, parents of students receiving special education services through a contracted service or third-party provider must provide written consent for the provision of these services. If the permissions are not received, then generally third parties cannot receive student information. There is no evidence that school districts are not complying with student privacy laws. However, this bill seeks to add another layer of bureaucracy and will require school districts to provide specific written notification to parents each time personally identifiable information is transferred from school districts to third parties. The language in this bill does not make it clear whether all data or specific data sharing must be addressed. Does a teacher need to notify the parents each time student progress is shared with a contracted specialist, such as a speech and language therapist? What does this mean for communications with the many contracted nurses filling in for school nursing vacancies? Is written notification required to provide the names and addresses of students to third-party transportation vendors? The language of 1695 does make it clear that teachers will be required to spend additional time on administrative tasks. This legislation is not necessary. It does nothing to enhance student privacy protections. We often hear in our committee that school districts pay too much for administrative costs. So why do we keep putting more clerical tasks on their plate? Let educators spend their time helping students learn. I urge you to vote no on the motion about to pass so that a new motion can be made. And Mr. Speaker, I ask for a division vote.
Representative Cordelli is recognized to speak for the motion.
Thank you, Mr. Speaker. The Family Education Rights and Privacy Act, FERPA, is a federal law that gives parents the right to have access to their children's educational records, the right to seek amendments to the records, and the right to have control over the disclosure of personally identifiable information from those records. Under FERPA, a parent shall provide written consent before a district can disclose student personally identifiable information. However, there are exceptions. Under FERPA Law 34 FRN 99.31, the school can disclose information under circumstances including to a school official or teachers with a legitimate educational need, but also to a contractor or consultant who performs services for the school that school staff might otherwise perform. It's okay to disclose information to them without parental consent. We can't do much about the federal law. The majority report says that this would violate information sharing in federal law, but it does not. It clearly states that this is not contrary to federal law. All it does is let parents know when confidential student information is being released to a third party. We have great concern about student privacy rights in our Constitution, and I know well about the requirement to let parents know about FERPA because I wrote the law. This bill is very simple. It just says that when information is released, parents must be notified when it is released, what information is being released, to whom it's being released, and why. The amendment just clarifies that the amendment that we just passed clarifies that this does not apply to information transfers between districts and school districts. We have already had a parents' rights piece of legislation defeated today, and now we're hearing that notifying parents is just another level of bureaucracy? Really? There are no penalties in this bill and no enforcement because federal law allows it. But shouldn't parents know what's going on and what information has been given out to other people? Mr. Speaker, I request a roll call vote.
The question is on the motion of ought to pass on House Bill 1695. Representative Cordelli requests a roll call. Is that sufficiently seconded? That is sufficiently seconded. This will be a roll call vote. Members, take your seats. The questions on the motion of ought to pass is amended on House Bill 1695, and this is a roll call vote. Representative Hall is recognized for a parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if I know that the privacy and security of student data is highly regulated through federal and state laws as well as in New Hampshire DOE standards, and if I know that New Hampshire school districts, charter schools, and private schools belong to the New Hampshire Student Data Privacy Consortium, whose primary goal is to address data privacy in schools. And furthermore, if I know that this legislation is not needed, as it would provide no additional data privacy to students and would place an unnecessary burden on school district employees, would I now push the red button so that another motion can be made? Thank you.
Representative Peternell is recognized for a parliamentary inquiry.
Mr. Speaker, if I know that Article 2B of the New Hampshire Constitution states an individual's right to live free from government intrusion in private or personal information is natural, essential, and inherent, if I know that under FERPA rules a school can disclose confidential student information to third parties without their parents' knowledge, if I know that this bill does not violate FERPA and merely requires notification, and if I know that a parent has a right to know when their child's information has been disclosed, would I now vote ought to pass and press the green button?
The questions on the motion of ought to pass is amended on House Bill 1695. This is a roll call vote. If you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds.
Representative Grossman.
Have all members present had an opportunity to vote? The House will attend to the state of the vote. 192 in the affirmative, 173 in the negative. The motion's adopted. Granger. The majority of the Committee on Environment and Agriculture, to which is referred CACR 14, an act relating to the environment and natural resources, providing that the state shall maintain and improve a clean and healthful environment for present and future generations. Having considered the same, report the same with the following resolution: resolved that it is inexpedient to legislate. Representative Jim Crichton for the majority of the committee. The minority of the committee, having considered the same and being unable to agree with the majority, report with the recommendation that the bill ought to pass. Representative Nicholas Germana for the minority of the committee. Representative Germana is recognized to speak against the committee report.
Thank you, Mr. Speaker. The primary concerns that were raised regarding this proposed constitutional amendment in our committee had to do with the claim that the language in the proposed amendment is vague. Well, I would submit, Mr. Speaker, that this is the very nature of fundamental rights. Statements of fundamental rights are always by nature vague. If we had before us in this body today the First Amendment to the United States Constitution or the Second Amendment, I think we would make the same claim, that they are vague. That's why we spent more than 200 years legislating and litigating in order to debate, to define, and to protect those fundamental rights. Likewise, with our own New Hampshire Constitution. It requires that we provide an adequate education for the children of this state. We all know how long it's taken us to get to where we are now, where we still can't define what it means to require an adequate education for the children of our state. Mr. Speaker, I submit that not a single member of this body would therefore conclude that it shouldn't be a constitutional right simply because we struggle to continue to define it. We weren't born being able to speak, and yet both the United States Constitution and the Constitution of the state of New Hampshire protect our right to free speech. Certainly none of us was born with a gun in our hands, and yet the Second Amendment and the New Hampshire Constitution defend our right to bear arms. Each and every one of us was born needing to breathe clean air and to drink clean water and to eat the produce that comes from clean land. There simply is no right more fundamental than the right to a clean environment. One of my colleagues in the committee raised a good point, one with which I do not disagree. He suggested that an amendment like this exists in order to invite lawsuits, as we have seen, for example, in the state of Montana. And my response is that's right, because that is how we debate and define and defend fundamental rights, is through our court system and through bodies such as this. We talk about the financial deficit, avoiding deficits, the irresponsibility of the financial deficit that has accrued in Washington. So my question, Mr. Speaker, today is what about the moral deficit? What about our responsibility as stewards of the environment to our children and to our grandchildren? Like most of my colleagues in this body, I am a parent. Like many of my colleagues in this body, I am a grandparent. And I know that there is nothing that I wouldn't give, including my life, to stand between my children or my grandson and imminent danger. And I'm confident that that is true of every parent and every grandparent in this body. Well, I suggest that I do more than suggest, we are facing imminent danger now. 2023 was the hottest year on record, and it is likely to be the coolest year of the rest of our lives. There is imminent danger now. And when we refuse to take action, we are refusing to accept the moral responsibility that we have to future generations. I ask my colleagues in the House to vote to overturn the ITL so that we can begin to accept the responsibility that we should have been accepting for a long time now and allow another motion to be made. Thank you.
Representative Creighton is recognized to speak for the committee report.
Thank you, Mr. Speaker. Fellow representatives, I rise in support of the Environmental and Agriculture Committee 13-7 bipartisan recommendation of ITL on CACR 14. The committee confirmed the vital importance of protecting our environment, but felt that the language in CACR 14 would not serve to enhance our efforts to improve the Granite State environment. Granite State is dedicated to improving our environment without this constitutional amendment. This body continues to consider bills on PFAS, on water safety, landfills, and many other environmental concerns. The Department of Environmental Services, their mission statement is to protect, I quote, to protect the protection and wise management of the state's environment are the main goals of the agency. Other states have enacted constitutional amendments similar to this. They've resulted in unforeseen suits, second and third order effects that have been more detrimental than supportive. The committee voted 13-7 in support of ITL and looks forward to taking action on concrete legislation to protect our environment. I urge you to support the committee recommendation and press that green button. Thank you very much.
The questions on the Majority Committee report of inexpedient to legislate on CACR 14. Representative Granger requests a roll call. Is that sufficiently seconded? That is sufficiently seconded. This will be a roll call vote. Members, take your seats. The questions on the motion of inexpedient to legislate on CACR 14. Representative Horrigan is recognized for parliamentary inquiry. The House will be in order.
Thank you very much. Thank you very much, Mr. Speaker. So I'm representing for PI. It's a series of rhetorical questions, but before I do that, I may point out the last time I participated in floor fight over CACR, the Speaker, who was then Speaker Chandler, actually had to cast a vote, so you may actually have to use your button, and I'll tell you which button I think you should press if that happens. Thank you, Mr. Speaker. If I know that we, the people of New Hampshire, have always had a strong connection to the earth, as shown by the fact we call ourselves granite staters after the bedrock that underlies almost the entirety of our state. If I know that we, the people of New Hampshire, have always understood the importance of passing on a clean and healthful environment to future generations so that our grandchildren can continue to live free long after we all die. And if I know that there's a good reason to be confident that a two-thirds supermajority of our fellow citizens, i.e. we, the people of New Hampshire, we'll be more than happy to affirm these principles by voting for CACR 14 in November. I think it's November 5th, 2014. Okay. Then, would I, and possibly you, Mr. Speaker, but would I then press the red button to overturn the pending motion of ITL to allow an alternative motion to be considered? That would be the red button. Thank you, Mr. Speaker.
Representative Colon is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if I know CACR 14 was copied and pasted from Montana's Constitution, where it's caused a hailstorm of litigation and judicial interpretation, and if I also know measures like this could call into question things like driving gas-powered vehicles, eating meat, burning firewood, and a laundry list of other things essential to living free in New Hampshire, and finally, if I know there's more fruitful ways of being better stewards of our environment than adding more words of art to our Constitution, would I please hit the green button to maintain its integrity? Thank you.
The House will be in order. The questions on the motion of inexpedient to legislate on CACR 14, and this is a roll call vote. If you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds. Have all members present had an opportunity to vote? The House will attend to the state of the vote. 197 in the affirmative, 168 in the negative. The motion's adopted. Nothing? 4, what reason does a member rise?
Mr. Speaker, I move that the debate on CACR 14 be placed in the permanent journal.
Without objection? So ordered. The majority of the Committee on Executive Departments and Administration, to which was referred CACR 11, an act relating to the retirement age for sheriffs, providing that sheriffs attaining the age of 70 years during their elected term in office shall be permitted to complete their current term. Having considered the same, report the same with the following resolution. Resolved, that it is inexpedient to legislate. Representative Jackie Grota for the majority of the committee. The minority of the committee, having considered the same and being unable to agree with the majority, report with the recommendation that the bill ought to pass. Representative Sherry Gould for the minority of the committee. The questions on the majority committee report of inexpedient to legislate. Are you ready for the question? All those in favor say aye. Aye. All those opposed, nay. No. The ayes have it, and the report's adopted. The majority of the Committee on Fish and Game and Marine Resources, to which was referred House Bill 1029, an act relative to exempting certain persons from requiring a New Hampshire landing license if such persons are not landing for the purpose of the sale of the lobster or crab they have caught. Having considered the same, report the same with the following resolution. Resolved that it is inexpedient to legislate. Representative Catherine Harvey for the majority of the committee. The minority of the committee, having considered the same and being unable to agree with the majority, report with the following amendment and the recommendation that the bill ought to pass with amendment. Representative Jonathan Smith for the minority of the committee. Representative Kofalt is recognized to speak against the committee report.
Thank you, Mr. Speaker. As legislators, we're called upon very often to look at a particular scenario, consider all of the permutations that might happen, and come to a decision as to how those should be handled. Once in a while, there's something we don't think of, and this bill pertains to one of those kinds of situations. Imagine that you enjoy the outdoors, you have a non-resident license to catch lobster and crabs in Massachusetts, but you have a home on the seacoast and you have a boat there. You take your boat out for the day, you go down to Massachusetts, maybe pick up some friends, do some lobstering, and you're in luck. You get some lobster. Now you bring it back, pull up to the dock, and as you start to take the lobster off the boat, you realize you have a problem. In order to carry that lobster from your boat to the dock and onto land, you need a landing license. You need a commercial lobster landing license. There is no non-commercial version of this. You need a commercial lobster landing license. The cost of that license is $500. Now, you do have an alternative. Before you come back to New Hampshire waters, you could pull your boat into a Massachusetts port, call up Uber on your mobile phone, drive the lobster back to New Hampshire, get back in the Uber, drive back to your boat, and go home. That probably cost you less than the $500 that it will cost you for a landing license. This bill simply removes that landing license requirement for anyone who is harvesting lobster for non-commercial purposes. Now, you will hear objections that the federal government needs to track the statistics with regard to the catch. If you have a non-resident Massachusetts lobstering license, you are already reporting that through the state of Massachusetts. So this bill simply removes what I believe is an oversight, kind of a bureaucratic snafu that leaves some people in some situations faced with that dilemma. Do they break the law? Do they pay $500? Or do they jump through hoops to try to get their lobster back home? I urge my colleagues to vote no so that a new motion can be brought forward. Thank you, Mr. Speaker.
Representative Darby is recognized to speak for the committee report.
Thank you, Mr. Speaker. Lobsters are the most valuable commercial fishery for New Hampshire, providing more than $34 million annually in revenues to commercial fishermen, with a total economic impact to the state of over $100 million. But lobsters are at risk. The catch has been on decline lately, and the 2023 harvest was the lowest since 2009. Even more alarming, young lobster stocks have declined almost 40% in recent years. It's clear management of this important economic resource is essential to maintaining healthy stocks to support the vital lobster fishery. But House Bill 1029 undermines the management process by eliminating the reporting of a recreational lobster catch landed in New Hampshire but taken outside of the state, such as federal waters and from nearby states. Since lobsters are a migratory species, they are managed by the Interstate Fishery Management Plan for American lobster, which requires reporting of lobsters in the states where they are brought ashore. New Hampshire Fish and Game uses landing permits for this reporting required by recreational lobster fishermen without a New Hampshire license. Unlike my colleague from Fish and Game mentioned to you, the New Hampshire resident cost for a landing license is $50, which can be reduced to $40 if they choose instead to buy a recreational lobster license. The $500 is for a non-resident. There are no adjoining states that offer non-resident landing permits. New Hampshire is the only state, so this isn't even reciprocal for $500. Further, as the Fish and Game Department is self-funded, a loss of revenue from permits reduces the funds available for the department's other critical resource services, such as rescuing stranded hikers and emergency services for snowmobiles and OHV accidents. New Hampshire Fish and Game opposed this bill, stating it would hamper their ability to meet the fishery management plan's requirement to accurately report the lobster landed in the state. They also described challenges in trying to differentiate recreational and commercial fishermen from other states. Numerous commercial lobster fishermen, including the Yankees Fishermen's Cooperative, also testified against it over lack of reporting, poaching potential, and enforcement concerns. The bill as introduced is even more problematic than a proposed amendment, potentially even permitting lobsters to be taken by diving. I ask you to support New Hampshire lobster fishermen and New Hampshire Fish and Game's responsibility to track and manage the crucial resource by voting in favor of the committee's bipartisan recommendation of inexpedient to legislate by pushing the green button. Thank you, Mr. Speaker, and I ask for a division vote.
Questions on the committee report of inexpedient to legislate on House Bill 1029. Representative Hull requests a roll call vote. Is that sufficiently seconded? It is sufficiently seconded. This will be a roll call vote. Members, take your seats. The questions on the committee report of inexpedient to legislate on House Bill 1029. Representative Carol Brown is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if I know that it is allowable for New Hampshire residents to catch lobsters or crabs recreationally in federal waters, and if I know that these lobsters or crabs caught recreationally are only intended for personal consumption, not commercial sale. If I also know that currently a New Hampshire resident must purchase a landing license in order to bring those lobsters home for his or her own personal use. And finally, Mr. Speaker, if I know that regardless of the price of that landing license, that license is an unneeded tax on the person who catches lobster and crabs for their own personal consumption. Therefore, would I then press the red button so that another amendment can be made? Thank you.
Representative Harvey is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if I know that this bill would eliminate the reporting process for lobsters taken outside of the state for recreational purposes, and if I know that that reporting process is actually required by the Interstate Management Plan for American lobsters, if I know that it is the duty of New Hampshire Fish and Game Commission to set the rules, regulations, and fees for all licensing, and if I know that having attended a New Hampshire Fish and Game Commission meeting, the Commission is now looking at this very issue as we speak concerning fees and regulations. And if I know that a non-resident landing license for recreational lobsters is $50, not $500, would I now press the green button to support the workings of the New Hampshire Fish and Game Commission, as well as our New Hampshire lobstermen? Thank you, Mr. Speaker.
The question is on the report of inexpedient to legislate on House Bill 1029, and this is a roll call vote. If you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds.
Representative Shapiro.
Have all members present had an opportunity to vote? The House will attend to the state of the vote. 186 in the affirmative, 179 in the negative. The report's adopted. The majority of the Committee on Fish and Game and Marine Resources, to which was referred House Bill 1100, an act relative to coyote hunting. Having considered the same, report the same with the following resolution: resolved that it is inexpedient to legislate. Representative Mike Ouellette for the majority of the committee. The minority of the committee, having considered the same and being unable to agree with the majority, report with the recommendation that the bill ought to pass. Representative Ellen Reed for the minority of the committee. For what reason does the member rise?
Make a motion.
State your motion.
Table.
Representative Spillane moves that House Bill 1100 be laid on the table, and this will be a division vote. Members, take your seats. The question is whether to lay House Bill 1100 on the table. Representative Spillane is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. If I know that this bill's been before us multiple times and we've disposed of it appropriately because Fish and Game sets their own dates and seasons, and if I further know that the reason that we set dates and seasons is to control a population that might be in danger without those dates and seasons, and coyotes are not such an animal, and if I know we have a very long day ahead of us, would I now press the green button to table this bill?
Representative Wendy Thomas is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if I know that House Bill 1100 is a bill that simply closes coyote hunting season during the weeks of coyote pup raising, like we do for other animals in New Hampshire, and that you can still hunt them outside of this season, and that you can always trap nuisance coyotes at any time, and if I know that by not hunting coyotes during this time period, you are actually controlling the coyote population far better than you would by hunting them. And finally, if I know that orphaned pups actually cause a greater threat to humans due to the lack of training from the adults in the pack, would I now press the red button to oppose this motion so that we can all hear the worthy and enlightening debate on this bill? Thank you, Mr. Speaker.
The question is whether to lay House Bill 1100 on the table, and this is a division vote. If you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds.
Representative Reynolds. Representative Tim Cahill.
Have all members present had an opportunity to vote? The House will attend to the state of the vote. 241 in the affirmative, 123 in the negative. House Bill 1100 is laid on the table. For what reason does a member rise?
To make a motion.
State your motion.
Having voting on the prevailing side, I move reconsideration of HB 1695 and urge the body to vote no.
Representative Sweeney moves reconsideration on House Bill 1695. Pretty sure it'll be at least a division vote. Yep, we got it. The question is whether to reconsider the previous vote on House Bill 1695, and this is a division vote. If you are in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds.
Representative Yokela.
Have all members present had an opportunity to vote? The House will attend to the state of the vote. 170 in the affirmative, 195 in the negative. Reconsideration fails. So we have one bill before lunch, and there is a debate. So if you stick around, we can get to the food quicker. The majority of the Committee on Health, Human Services, and Elderly Affairs, to which was referred House Bill 1194, an act relative to the definition of non-communicable disease. Having considered the same, report the same with the following amendment and the recommendation that the bill ought to pass with amendment. Representative Mark McLean for the majority of the committee. The minority of the committee, having considered the same and being unable to agree with the majority, report with the following resolution. Resolved that it is inexpedient to legislate. Representative James Murphy for the minority of the committee. The amendment is 0809H, printed in House Record 9 on page 54. The question's on the adoption of the amendment. Are you ready for the question? All those in favor say aye. Aye. All those opposed, nay. The ayes have it, and the amendment's adopted. Now the motion is ought to pass as amended. Representative Weber is recognized to speak against the report.
Thank you, Mr. Speaker. House Bill 1194, as written and amended, removes the word infectious from the definition of non-communicable diseases, and as such, it effectively requires immunization only against those diseases, except for tetanus, which we just fixed, that can transfer person to person. While the amendment removing tetanus improves the bill, it still leaves open the problem that there are other diseases that can transfer and are very readily transferable without person-to-person contact, and they may require immunization to protect the population at large. Let's be clear about the science involved in the accuracy of the proposed definition and impact. While all communicable diseases are infectious, not all infections are communicable. For example, and similar to tetanus, there are many infections and variable vectors that can transmit diseases that can be equally dangerous to the public. As climate change is present among us, other diseases may become prevalent within our communities, and we do not want to harm our public or handicap the future health services in the future. COVID is the most recent example demonstrating that this deadly virus can survive on surfaces such as countertops and doorknobs and not be transmitted person to person. Mosquitoes are excellent vectors for the transmission of malaria, Zika, and yellow fever. Legionnaire's disease is a deadly pneumonia transmitted with bacteria in lakes and streams and transmissible to humans without person-to-person contact. Germs can be transmitted on common surfaces such as keyboards, toothbrush holders, cell phones, and remotes. It's why we are advised to clean surfaces and wash our hands regularly. Fortunately, these diseases are not as prevalent here in New Hampshire as in other areas of the world today, but with the rapid ascent of climate change, we may increasingly see non-communicable diseases become prevalent within our communities, which may be responsive to highly effective vaccines. This bill would narrowly define non-communicable and compromise future public health initiatives. We do not want to compromise the health care of our communities by handicapping our public health services with illogical and non-scientific statutes. I urge you to vote against the motion of ought to pass as amended so that another motion can be made, and I request a division vote.
Representative Wayne McDonald is recognized to speak for the committee report.
Thank you, Mr. Speaker. House Bill 1194 removes the word infectious from the definition of a non-communicable disease as it relates to the requirement for immunization and clarifies that a non-communicable disease is a disease that is not transmissible from person to person. The United States and the state of New Hampshire have always understood that the individual has a fundamental right to exercise sovereignty over their own medical decisions. And this understanding is the driving force behind the Patient's Bill of Rights and the requirements around informed consent. These concepts also carry over into the discussion about vaccination requirements. In spite of this understanding, it is also recognized that an individual's medical sovereignty is not absolute. And in its landmark 1905 decision, Jacobson versus Massachusetts, the United States Supreme Court put forth the grounds upon which the state might override individual sovereignty and mandate a vaccine. In Jacobson, the court argued that the state could not arbitrarily put forth a vaccine mandate, but it might proceed if two conditions are met. First, does the mandate have a substantial relation to its intended object? And second, does the mandate not violate a fundamental right? The bipartisan majority of the Health and Human Services and Elderly Affairs Committee felt that in the case of diseases transmitted from person to person, both of these conditions are met. For example, if a nurse in a maternity ward were not vaccinated for whooping cough, it could pass through the ward like wildfire with potentially devastating consequences for the infants housed within. However, the majority also felt that requiring vaccination for diseases spread by non-human vectors falls outside of the standards set in Jacobson, and that the decision to pursue vaccination in such cases should rightly be left to the individual or the parents of the case of minor children being involved. The language presented in HB 1194 respects the spirit of Jacobson by upholding the right to mandate to preserve herd immunity in the case of person-to-person transmission, while defaulting to individual choice in all other cases. Concern was raised about what this law might do to requirements around the tetanus vaccine, and as was earlier stated, the committee drafted an amendment, which we just voted on, carving out an exception to preserve the immunization mandate for tetanus, given the great benefit and long history of that particular vaccine. Please join the bipartisan committee of the Health and Human Services Committee in supporting HB 1194 and press the green button. Thank you, Mr. Speaker.
The questions on the report about to pass as amended on House Bill 1194, and this will be a division vote. Members, take your seats. The questions on the committee report about to pass as amended on House Bill 1194. Representative Weber is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. If I recognize that there are many diseases that are terribly, terribly infectious, but that are not spread directly person to person, would I vote no on the recommendation of ought to pass as amended?
Representative McDonald is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. If I know that this legislation balances the right of the individual with the rights of those around them, and if I know that this was voted by, ought to pass as amended by a bipartisan majority of the Committee of Health and Human Services and Elderly Affairs, would I press the green button? Thank you.
The questions on the Majority Committee report about to pass as amended. This is a division vote. If you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds. Have all members present had an opportunity to vote? The House will attend to the state of the vote. 191 in the affirmative, 171 in the negative. The report is adopted. For what reason does a member rise?
Having voted on the prevailing side, I move reconsideration and urge the body to vote no.
Representative Sweeney moves reconsideration of House Bill 1194. Are you ready for the question? This will be a division vote. Members probably already in your seats. Yep. The question is whether to reconsider House Bill 1194. If you are in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds. Have all members present had an opportunity to vote? The House will attend to the state of the vote. 171 in the affirmative, 192 in the negative. Reconsideration fails.
Just so everybody knows, the reason I wasn't presiding this morning is you can tell I woke up this morning barely able to speak. So I want to thank the Deputy Speaker. Maybe a little bit later this afternoon, if I get my voice back, I'll come back. But I didn't think you wanted to sit there and listen to a squeaky mouse like I am. So, but lunch will be an hour and 15 minutes. And I guess there is a free lunch in the cafeteria.
So we'll be back at 1:20.
Back at 1:20.
and Elderly Affairs, to which was referred House Bill 1213 FN, an act relative to immunization requirements for private schools and child care agencies. Having considered the same, report the same with the following amendment and the recommendation that the bill ought to pass with amendment. Representative Leah Cushman for the majority of the committee. The minority of the committee, having considered the same and being unable to agree with the majority, report with the following resolution. Resolved that it is inexpedient to legislate. Representative William Palmer for the minority of the committee. Representative Palmer is recognized to speak against the report, and let's quiet down and hear him.
Thank you, Mr. Speaker.
Good luck. A lot of loud voices. That time is over. I know I'd like to get home before 8 or 9 o'clock, so let's just hear the representative.
Thank you. I'm a physician who believes prevention is the best medicine and speak in opposition to HB 1213 FN. While the amendment that we will discuss would make the bill better, we're not doing? Okay. So I just need to do the...
Mr. Speaker? You are correct.
It's just the bill.
Okie dokie.
So,
No, there's no debate on the amendment.
Right, but I didn't call it. The question is on Amendment 0810H, printed in House Record 9 on page 61. Are you ready for the question? All those in favor say aye. Aye. All those opposed, nay. The ayes have it. The amendment's adopted. My apologies, Representative Palmer. You're up.
Thank you, Mr. Speaker. I'm a physician who believes prevention is the best medicine and speak in opposition to HB 1213 FN. While the amendment just passed makes the bill better by continuing to require private schools to maintain documentation of children's immunization records or exemption, the bill deletes the requirement for child care facilities, which is not in the best interest of public health. The bill is opposed by the New Hampshire Medical Society, the New Hampshire Pediatric Society, the Division of Public Health Services of the Department of Health and Human Services, the YMCA, which serves thousands of children in their early education programs, and New Futures, among others. The YMCA wrote, and I quote, "Immunization requirements help protect the health and safety of the children and staff in our programs and reduce the likelihood of classroom closures in the event of an outbreak of communicable disease. Measles outbreaks have occurred in multiple U.S. states already in 2024, and polio reemerged in New York State in 2022. Despite the controversies around vaccines, vaccines remain one of the most effective public health prevention measures. We don't want to go back to 1938 when my mother, who had contracted polio at the age of 11, was just lucky to survive. I'm also concerned that the Department of Health and Human Services Bureau Chief for Reporting Requirements testified before our committee that this bill would put New Hampshire out of compliance with federal reporting requirements. This could jeopardize federal child care block grants. This bill would weaken one of our most effective public health protection measures for young children and child care staff, would put us out of compliance with federal reporting requirements, and would not significantly reduce administrative burden on child care agencies. Please vote against the OTP motion. Thank you, Mr. Speaker, and I'd like a division vote, please.
Representative Berry is recognized to speak for the report.
Thank you, Mr. Speaker. With all due respect to my member from the other side, this is not a bill about vaccines. This bill does not change the requirement to get vaccinated. That is RSA 141-C. What this bill does is it eliminates the reporting requirement for child care centers, which have no business collecting this information. This is private health information. This has nothing to do with taking a vaccine. You still have to get a vaccine or you have to sign the religious waiver. These child care centers have the option to hand out a religious waiver. They have no ability to determine if that religious waiver, if signed, is legitimate or not. It would be grossly inappropriate for them to do so. What does happen is the Department of Health and Human Services issues citations for this massive paperwork requirement. Bluntly speaking, the reason why my colleague from the other side wrote from the YMCA is because the YMCA has a staff of hundreds. So it's very easy for them to maintain this. But if you are one of the many small businesses servicing children between maybe 30 or 40 or 50 children, the average size of a child care center in the state of New Hampshire, this is a very burdensome requirement. So what happens when they're out of requirement with this? What happens is they get a notice of findings. Then insurance companies go and pull that notice of findings, and they raise the rates on the child care providers. Those rate costs are then passed on to working families. So this bill does not stop the requirement to get vaccinated. All it does is remove a reporting requirement that is uniquely placed onto child care centers. We don't place this burden on at-home care. We only place it on child care centers. So if you support getting the government out of this unnecessary function, let child care centers provide child care and stop being reporting arms for DHHS, I urge you to please pass this bill.
The questions on the committee report of ought to pass as amended. Representative Granger requests a roll call. Is that sufficiently seconded? That is sufficiently seconded. This will be a roll call vote. Members, take your seats. The questions on the Majority Committee report of ought to pass as amended on House Bill 1213. Representative Palmer is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if I know that many New Hampshire healthcare organizations opposed this bill and in fact indicated they were worried that the rate of vaccination would go down if this passes, and if I know the Department of Health and Human Services testified that this bill would put New Hampshire out of compliance with federal reporting requirements and jeopardize child care block grants, which might lose money for the daycare centers that are really struggling at this point. And if I know our primary focus should be on the health and safety of our children and not on paperwork burden, then would I now press the red button so another motion can be made? Thank you, Mr. Speaker.
Representative Berry is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. If I know that this bill does not remove the vaccination requirement for children in RSA 141-C, and I know, Mr. Speaker, that this bill would lower the cost of child care and reduce an unnecessary paperwork burden, and, Mr. Speaker, I know that the state has other ways to collect this information that doesn't involving an entity that is not in the business of health care, would I now vote green to uphold the ought to pass as amended motion?
Questions on the Majority Committee report of ought to pass as amended on House Bill 1213, and this is a roll call vote. If you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds. Have all members present and an opportunity to vote? The House will attend to the state of the vote. 189 in the affirmative, 173 in the negative. The report is adopted. For what reason does a member rise?
To make a motion, Mr. Speaker.
State your motion.
I'd like to move to special order HB 1250 to the next order of business. I'd like to speak to my motion.
You recognize to speak.
Thank you, Mr. Speaker. The prime sponsor of this bill has an urgent need to leave prior to 3 p.m. today, and I want to make sure that he has an opportunity to present his bill and that we have an opportunity to tell you what it's about. So I'm asking that we move it up to the next order of business. Thank you. The prime sponsor of the bill has an urgent need to leave before 3 p.m. today, so I am asking that we special order this bill to the next order of business so that we can present our views to the Speaker and to our colleagues.
The motion is to special order House Bill 1250 to the next order of business. Are you ready for the question? All those in favor say aye. Aye. All those opposed, nay. No. The ayes have it. The bill is special ordered. The majority of the Committee on Municipal and County Government, to which is referred House Bill 1250, an act enabling the creation of certain village districts, having considered the same, report the same with the recommendation that the bill ought to pass. Representative Laurel Stavis for the majority of the committee. The minority of the committee, having considered the same and being unable to agree with the majority, report with the following resolution: resolved that it is inexpedient to legislate. Representative Tim Cahill for the minority of the committee. Representative Richard Brown is recognized to speak against the committee report.
Thank you, Mr. Speaker. I rise in opposition to the ought to pass motion. This legislation would permit the creation of village districts for the alleged purpose of protecting lakes and bodies of water. There are many issues that arise that make this legislation unacceptable. First, these districts could and would likely span multiple towns. For example, Lake Winnipesaukee could include Moultonborough and Alton, about 20 miles apart, at opposite ends of the lake, and then all towns in between. If you look at Moultonborough alone, for instance, we have both Lake Canesaca and Lake Winnipesaukee, with significantly different issues. Canesaca with serious cyanobacteria issues, and Lake Winnipesaukee with significantly different issues, which are more general and of a wider variety. Potential issues that should be addressed specifically based on the local impacts. Are the interests of those in Alton, Wolfboro, Laconia, and Moultonborough the same? I suggest no. Next, in the process of creating these districts, properties included in these districts would vote to approve or disapprove. If 51% voted to approve and 49% voted against, the 49% would be subject to assessments, fees, and added taxes. Troubling is that fines and penalties could be assessed to perceived offending parties. What's troubling is that this was mentioned specifically as a positive note when we received written testimony. Now to the properties the planners would include in the village districts. Those properties would all be lake or waterfront properties, right? Wrong. Properties could include those not along waterfront, as for example, elevated lands not abutting a water body could be claimed to have runoff effects. So they are included in the district. Or how about a property with septic system that creators believe may be contributing to seepage into the lake? Or what about a farmer's property miles from the lakefront, whereas acreage is along a stream that meanders its way to the lake? Can the planners of the district say fertilizer on the farmer's land may be leaking into the stream so that his land, as well as the properties along the stream, are also included? And everyone here can imagine how you could have your own scenario where properties not on the body of water could be gerrymandered into the district. While sponsors see the virtue in this bill, many assert and believe that this would become a huge infringement on their property rights. Many lakes have formed associations as a voluntary basis to accomplish what the bill wishes to do. For instance, in Moultonborough, where I live, Lake Kennesaca has an association which is currently addressing a serious cyanobacteria issue. I live on Moultonborough Bay on Winnipesaukee, and we have the Geneva Point Association, which looks at lake issues and helps fund them voluntarily. The clear difference is that this bill uses the heavy hand of bureaucracy in a mandatory top-down, all-in way. Those of us against top-down, all the way in, those of us against the OTP motion prefer a lighter touch and the use of a bottom-up local approach. I encourage my colleagues to join me in opposition to this anti-property rights legislation by pressing the red button so that a better motion can be made. Thank you, Mr. Speaker.
Representative Sychterz is recognized to speak for the committee report.
Thank you, Mr. Speaker. Mr. Speaker, HB 1250 adds the protection and remediation of water surface quality to the list of purposes for which a village district may be formed. It has bipartisan support, and if adopted, will be a much-needed tool for protecting New Hampshire's lakes and other important bodies of water. This is bottom-up legislation. This is enabling legislation only. It doesn't compel anyone to do anything. Instead, it allows those who live on or near lakes to adopt a form of municipal government that goes back in New Hampshire law to at least 1957. Village districts exist to provide services that are beyond the scope of a municipality's ability. Their rules and ordinances affect only those who live in the district. In adding these few words to the existing law, village districts will now be actively able to protect their lakes and ponds. New Hampshire's lakes are under increasing stress. Seasonal and toxic cyanobacteria blooms have become a regular occurrence, threatening lakes, closing them to recreation, and even imperiling our drinking water supply. A village district formed with the purposes outlined in HB 1250 would be able to analyze what is causing these deadly blooms and devise ways to remediate them. Such a village district would also give members access to research and remediation tools not available to them as private citizens. Again, nothing in HB 1250 forces anyone to do anything. And it doesn't introduce any radical change to existing and long-settled law. It simply gives citizens a common cause around which to gather and provides vital tools to help our lakes and ponds. Mr. Speaker, a New Hampshire without pristine natural waterways is a New Hampshire no one wants to envision. I urge you to see HB 1250 as a way to help prevent that from happening and to support the committee's ought to pass motion. Thank you, Mr. Speaker.
A division vote's been requested. This will be a division vote. Members, take your seats. Representative Cherish requests a roll call. Is that sufficiently seconded? It is. This will be a roll call vote. questions on the Majority Committee report ought to pass. Representative Tim Cahill is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. If I know that creating legislation that could take away individual property rights is not the way we do things in the live free or die state, would I now press the red button to preserve the rights of individual homeowners?
Representative Wolf is recognized for parliamentary inquiry.
Thank you, Mr. Speaker and fellow representatives. If I know that this is only enabling legislation, and there are 14 items which are covered under the existing special districts legislation, this would create a 15th one. And if I know that HB 1250 follows a long list of communities that have helped themselves without burdening others who are not affected and form village districts for a specific purpose. And if I know that combining the efforts of several towns will provide a greater opportunity for grants, outside funding, and research. And if I know that this bill is desired by many towns within the state that wish to protect their surface waters. And if I know that without allowing multiple areas within various towns to work together, we are risking the quality of our water bodies that we hold so near and dear, would I then press the green button and pass HB 1250? Thank you.
The questions on the Majority Committee report about to pass on House Bill 1250, and this is a roll call vote. If you're in favor, press the green button. If you're opposed, press the red. Just giving him a chance to get back. Oh, you're good. Voting stations are open for 30 seconds. Have all members present had an opportunity to vote? The House will attend to the state of the vote. 182 and 182, the motion fails. Cahill. Representative Cahill moves inexpedient to legislate. Are you ready for the question? For what reason does the member rise?
I move to table House Bill 1250.
Representative Wilhelm moves to table House Bill 1250. This will be a division vote. Members, take your seats. Representative Turcott requests a roll call. Is that sufficiently seconded? Yep, this will be a roll call vote. The question is whether to lay House Bill 1250 on the table, and this is a roll call vote. If you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds. Have all members present had an opportunity to vote? The House will attend to the state of the vote. 182 in the affirmative, 183 in the negative. Tabling fails. Next, the question is now inexpedient to legislate on House Bill 1250. Are you ready for the question? Imagine that. Since you're all here, this will be a division vote, but we do... Oh, okay, then. Well, Representative Turcotte would like another roll call, and it is sufficiently seconded. This will be a roll call vote. Roll call. All right, one more time. The question is inexpedient to legislate on House Bill 1250, and this is a roll call vote. You should be getting good at this by now. If you're in favor of ITL, press the green button. Opposed, press the red. Voting stations are open for 30 seconds.
Representative Dennis Mannion.
Have all members present had another opportunity to vote? The House will attend to the state of the vote. 184 in the affirmative, 180 in the negative. The motion is adopted. And hi. For what reason does a member rise? We're just not tired of voting on 1250 yet, are we?
Having voting on the prevailing side on HB 1250, I move reconsideration and urge the body to vote no.
Sure. So the motion is reconsideration, and look at that. A pre-seconded roll call. This will be a roll call vote. Members, take your seats. The question is whether to reconsider the beloved House Bill 1250. If you are in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds. Have all members present had an opportunity to vote? The House will attend to the state of the vote. 179 in the affirmative, 187 in the negative. Reconsideration fails. For what reason does that member rise?
Mr. Speaker, having voting on the prevailing side of HB 1213, I move reconsideration and urge the body to vote no.
Which one? Representative Sweeney moves reconsideration on House Bill 1213. A division's been requested. This will be a division vote. Members, take your seats. The motion is whether to reconsider House Bill 1213. This is a division vote. If you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds. Have all members present had an opportunity to vote? The House will attend to the state of the vote. 172 in the affirmative, 193 in the negative. Reconsideration fails. I recognize you because you're here all the time. For what reason does the member rise?
Mr. Speaker, having voting on the prevailing side on HB 1266, I move reconsideration and urge the body to vote no.
Representative Sweeney moves reconsideration on House Bill 1266. And this will be a division vote. Members, take your seats. The question is whether to reconsider House Bill. Have all members present had an opportunity to vote? The House will attend to the state of the vote. 173 in the affirmative, 192 in the negative. Reconsideration fails. For what reason does the member rise?
Mr. Speaker, I have a question for the chair.
Okie dokie.
With great respect, Mr. Speaker, understanding the similarity of our names, given how late we are in the legislative calendar, understanding that we have only several weeks more before the deadline, and understanding how many bills we have today to vote on, is it possible that continued requests for reconsideration might be considered dilatory?
No, it's not dilatory. Dilatory is successive motions of no point on the same thing. And you're up. For what reason does the member rise?
To make a motion?
Sure.
I move that we special order HB 1416 to the next order of business.
So what was the number?
1416.
All right, you can speak to your motion.
Thank you. I'd like to make this request to special order 1416 to the next order of business as a courtesy to the sponsor, who is scheduled to speak on it later today but may have to leave before we get to it this evening. Appreciate your indulgence in this.
The motion was to special order House Bill 1416 to next order of business. To the next order of business. This will be a division vote. Members, take your seats. The question is whether to special order House Bill 1416 to the next order of business. If this is a division vote, if you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds.
Representative Gould. Representative Gould. Thumbs up or thumbs down? Representative Trotter. Representative Richard Brown.
Representative Richard Brown. Representative Panic. Representative Andrews. Representative Reynolds. Representative O'Neill. Representative Seibert, thank you. Representative Wolf. Representative Carey. Representative Carey. Representative Julie Smith. Representative Tellez. Representative Weber, I can't see her. Thank you. Thank you. Representative Herbert Nomi. Thank you. And Representative Allison Turcotte.
That ate up some time. Have all members present had an opportunity to vote? The House will attend to the state of the vote. Does he need to update that? All right. 336 in the affirmative, 29 in the negative. The motion passes. Special Order 1416 to now. For what reason does the member rise?
I move to indefinitely postpone HB 1416.
Not in order yet.
You have to read the report and then you can make a motion.
I got to read it in first. The majority of the Committee on Transportation, to which was referred House Bill 1416 FN, an act relative to prohibiting parking of non-electric vehicles in spaces designated for charging electric vehicles. Having considered the same, report the same with the following resolution. Resolved that it is inexpedient to legislate Representative John Sellers for the majority of the committee. The minority of the committee, having considered the same and being unable to agree with the majority, report with the recommendation that the bill ought to pass. Representative Catherine Rombo for the minority of the committee. For what reason does the member rise?
To make a motion,
State your motion.
I move to indefinitely postpone House Bill 1416.
Representative Sweeney moves to indefinitely postpone House Bill 1416. Are you ready for the question? Thought so. This will be a division vote. Members, take your seats.
Well, yeah, I think so. Is he going to do a PI? So I will be against it.
The question is whether to indefinitely postpone House Bill 1416. Representative Sweeney is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if I know we only have a few weeks left until our legislative deadlines, and if I further know that we can move on with business today by voting yes on indefinite postponement, and if I further know that we didn't start the fire, would I now vote green? Thank you.
With apologies to Billy Joel. Representative Sychterz is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. If I know that we move this bill forward on an earlier vote in recognition of respect for our colleagues on the other side of the aisle, as the prime sponsor who has to leave, and if I know that the indefinite postponement motion is taking up way more time than the two PIs that are scheduled for this bill, would I now vote the red button so that we can at least hear the two PIs for the bill on its merits?
The question is whether to indefinitely postpone House Bill 1416. This is a division vote. If you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds. Have all members present had an opportunity to vote? The House will attend to the state of the vote. 189 in the affirmative, 176 in the negative. House Bill 1416 is indefinitely postponed. The majority of the Committee on Health, Human Services, and Elderly Affairs, to which was referred House Bill 1240, an act relative to eating disorders as a qualifying condition for the therapeutic cannabis program. Having considered the same, report the same with the following resolution. Resolved that it is inexpedient to legislate. Representative David Nagel for the majority of the committee. The minority of the committee, having considered the same and being unable to agree with the majority, report with the recommendation that the bill ought to pass. Representative Seth King for the minority of the committee. For what reason does a member rise?
To make a motion.
State your motion.
Mr. Speaker, I'd like to table House Bill 1240 and a division.
Representative Leon moves that House Bill 1240 be laid on the table. Are you ready for the question?
She asked for division.
She asked for a division? Okay. It'll be a division vote. Members, take your seats.
Okay, yes. Okay, yes, I just didn't want you to walk in front and get in trouble.
The question is whether to lay House Bill 1240 on the table, and this is a division vote. Representative Leon is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. If I know that this body has already passed House Bill 1278, which is far broader reaching, allowing physicians to write a recommendation for anybody who is an adult. And further, if I know that that bill stands a far greater chance of ultimately becoming law than this bill. And lastly, if I know that I was going to make a 420 joke about 45 minutes ago, would I then table this bill so that we can get to our other bills? Thank you.
Representative King is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. If I know that there have been a lot of people looking forward to this bill coming to the floor, and if I believe that this bill has a strong chance of passing, and also if I believe that the bills referenced earlier haven't been signed into law and there's still things left to be determined, would I vote no on the tabling motion? Thank you.
The question is whether to lay House Bill 1240 on the table. This is a division vote. If you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds. Have all members present had an opportunity to vote? The House will attend to the state of the vote. 310 in the affirmative, 54 in the negative. House Bill 1240 is laid on the table. All righty. The majority of the Committee on Health, Human Services, and Elderly Affairs, to which is referred House Bill 1482, an act relative to the sale of human blood and organs. Having considered the same, report the same with the following resolution. Resolved that it is inexpedient to legislate. Representative Seth King for the majority of the committee. The minority of the committee, having considered the same and being unable to agree with the majority, report with the recommendation that the bill ought to pass. Representative Yuri Polozov for the minority of the committee. For what reason does the member rise?
I'd like to make a motion, Mr. Speaker.
State your motion.
I'd like to move to table House Bill 1482.
Representative Wayne McDonald moves to lay House Bill 1482 on the table. Are you ready for the question? It'll be a division vote. Members, take your seats. Who did?
Anastasio requested a roll.
Representative Anastasio requests a roll call. Is that sufficiently seconded? It is not sufficiently seconded. Still a division vote. Questions whether to lay House Bill 1482 on the table. Representative Wayne McDonald is recognized for a parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if I know that this bill was voted on in the Health and Human Services and Elderly Affairs Committee overwhelmingly by a bipartisan majority of 18-1, and we voted against this bill, would I now vote in favor of tabling? Thank you, Mr. Speaker.
Representative Anastasio is recognized for a parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if I know it is a self-evident truth that I possess sovereignty over my own body, and if I know the state purporting to own my body is akin to livestock, and if I know that legalizing organ sales will bring supply to the market and help those whose life depends on it, and further, if I know those who receive organs would also like the option to give the donor more than a thank you card, if I know this will decrease hospital occupancy and costs, freeing up care for all, if I know this will reduce black market activity, and if I know that people want to be good people and help others, but sometimes they need a little cash to grease the wheels, then when I press the red button so we can discuss this bill. Thank you, Mr. Speaker.
The question is whether to lay House Bill 1482 on the table. This is a division vote. If you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds.
Representative Reed.
Well, members present had an opportunity to vote. The House will attend to the state of the vote. 326 in the affirmative, 38 in the negative. House Bill 1482 is laid on the table. The Committee on Health, Human Services, and Elderly Affairs, to which was referred House Bill 1660 FN, relative to coverage of certain procedures for minor children under the state's Medicaid program, comes to us without recommendation. Representative Kofalt moves ought to pass. Representative Weber is recognized to speak against the motion.
Thank you, Mr. Speaker. House Bill 1660 extends far beyond the prohibitions that we already voted on earlier this year. That was a prohibition on genital gender reassignment surgery. This bill would prohibit Medicaid from paying for any kind of gender reassignment surgery. So that means breast surgery as well as genital surgery. Now, we are all agreed that for the most part, it is best to wait until 18 before these decisions are taken. However, in some cases, it is absolutely life-saving surgery. And if agreed to by the individual's parent or guardian, the various healthcare providers, it's a real necessity for the individual that needs it, and families should be left to make those decisions. And if we prohibit Medicaid for paying for this surgery, we are creating a discrimination against those who are poor. We're creating two different kinds of medical practice, one for those with resources and one for those without. And secondly, we are creating a discriminatory category because we are labeling one particular group of people as being unworthy of medical treatment. The concern that I have is that this bill is part of what is an emerging fabric of attacks on people who are LGBTQ+. And I don't think we ought to be going down that road. I don't think we ought to be creating two tiers of medical practice. And I think we ought to be pressing the red button on ought to pass so a better motion can be made. Thank you.
Representative Kofals recognized to speak in support of the motion.
Thank you, Mr. Speaker. In early January, this House took the position that children should not be undergoing permanent, irreversible surgery in New Hampshire that they may very well regret. This bill is extraordinarily simple. It states that the New Hampshire Medicaid program will not cover gender reassignment surgery for children. To those who would say this creates some kind of two-tier healthcare system, there are numerous private healthcare plans that do not cover these procedures for children or adults. The opposing committee report asserts that this bill is discriminatory. This bill merely asserts that taxpayers should not be on the hook to pay for gender reassignment surgery for minors. Not only is that taking money, scarce public resources out of public coffers, it is also potentially creating a liability for the state of New Hampshire because there are huge issues, huge questions remaining around liability when someone comes back later and says, I was young, I didn't know what I was doing, and I was talked into this or not adequately screened. The opposing committee reports asserts that this is discriminatory. I would assert that there are a number of things that we do not allow children to do in the state of New Hampshire, including drinking alcohol, smoking cigarettes. In fact, in the state of New Hampshire, we do not allow children, anyone under the age of 18, to use a tanning salon. In light of that, it does not sound discriminatory. It sounds like common sense that we do not want to use taxpayer funds to fund gender reassignment surgery that is irreversible and highly likely to cause later regrets. Mr. Speaker, I urge my colleagues to vote in favor of the OTP motion, and I ask for a roll call vote. Thank you, Mr. Speaker.
For what reason does the member rise?
To make a motion.
State your motion.
I wish to table HB 1660.
Representative Murray moves that House Bill 1660 be laid on the table. Today, somebody asked for a roll call. Representative Janman requests a roll call. It is sufficiently seconded. This will be a roll call vote. Members, take your seats. The question is whether to lay House Bill 1660 on the table. Representative Murray is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if I know that we already have a long day ahead of us and we don't need to go back and forth on controversial bills, and if I also know that the LGBTQ youth of New Hampshire have already faced so much harassment from this body that we do not need to add on to the fear that they're feeling right now. And Mr. Speaker, if I know that this bill sets up a two-tiered system within our public health care, deciding who and who does not receive that health care, would I now press the green button to table this bill?
Representative Kofals recognized for parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if I know that the majority of New Hampshire residents do not support the idea of irreversible gender reassignment surgery for minors, and that they don't want to pay it with their tax dollars or incur future liabilities for the state of New Hampshire, would I then press the green button? I'm sorry. My apologies. Would I then press the red button so that we could move forward with the motion that was on the floor? Thank you.
The question is whether to lay House Bill 1660 on the table, and this is a roll call vote. If you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds.
Representative Toll.
All members present had an opportunity to vote. The House will attend to the state of the vote. 174 in the affirmative, 188 in the negative. The motion fails. Now the question is to pass on House Bill 1660. Representative Granger requests a roll call. Is that sufficiently seconded? That is sufficiently seconded. This will be a roll call vote. Members, take your seats. Question before the House is the motion about to pass on House Bill 1660. Representative Weber is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. If I know that the vast majority of the citizens of New Hampshire want parents, families to make decisions with their minor children in consultation with medical providers and other counselors of that family's choosing. And if I know that I do not want to deny appropriate medical care to one specific category of people, would I now press the red button so a better motion can be made?
Representative Kofaltz recognized for parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if I know that the majority of the residents of New Hampshire still do not believe that their tax dollars should pay for irreversible surgeries for minors that they may soon regret, would I this time press the green button so that this ought to pass motion succeeds? Thank you, Mr. Speaker.
Questions on the motion about to pass on House Bill 1660. This is a roll call vote. If you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds.
Representative Munns.
Of all members present had an opportunity to vote. The House will attend to the state of the vote. 193 in the affirmative, 169 in the negative. The motion's adopted. For what reason does the member rise?
Having voted on the prevailing side, I move reconsideration on House Bill 1660 and urge the body to vote no.
Representative Sweeney moves reconsideration on House Bill 1660. Are you ready for the question? Yep. This will be a division vote. Members, take your seats. The question is whether to reconsider House Bill 1660. This is a division vote. If you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds. Have all members present had an opportunity to vote? The House will attend to the state of the vote. 171 in the affirmative, 192 in the negative. Reconsideration fails. For what reason does the member rise?
I'd like to indefinitely postpone 1706, please.
What? I didn't hear that. Yeah, okay. The majority of the Committee on Health, Human Services, and Elderly Affairs to which is referred House Bill 1706 FN, an act relative to notice required prior to circumcision procedure. Having considered the same, report the same with the recommendation that the bill be referred for interim study. Representative Leah Cushman for the majority of the committee. The minority of the committee, having considered the same and being unable to agree with the majority, report with the following resolution. Resolved that it is inexpedient to legislate. Representative David Nagel for the minority of the committee. The questions on the majority committee report of interim study. Are you ready for the question? All those in favor say aye. Aye. All those opposed, nay. The ayes have it, and the report's adopted. Committee on Judiciary, to which was referred CACR 12, an act relating to the definition of the word cherish, providing that the 1784 word cherish shall be replaced by the 2024 word cherish. Having considered the same, report the same with the following resolution. Resolved that it is inexpedient to legislate. Representative Marjorie Smith for the committee. Representative Dan McGuire is recognized to speak against the committee report.
Thank you, Mr. Speaker. CACR 12 is a constitutional amendment designed to correct the erroneous New Hampshire Supreme Court 1993 Claremont decision. That decision said that this phrase in Part 2 of Article 83 of the Constitution, which reads in part, "It shall be the duty of legislators to cherish the interest of literature, the sciences, and all seminaries and public schools," that they ruled that that requires us to allocate funds from statewide sources to pay for an adequate education for all students. CACR 12 is designed to nudge the Supreme Court to a correct interpretation of that part of the Constitution. So first of all, I want to dispel the notion that the Constitution is something that could only be understood by experts and judges and the Supreme Court and so on. The Constitution was created in 1784. The draft was made by a committee who took the Constitution from Massachusetts, made some modifications, and sent it out to all of the towns where the people read it. They met in their annual meeting and voted on it. And they voted it down. And they sent suggestions back to the committee. The committee, over the next period, made changes, sent new copies out to the towns. All the people read it. They discussed it. They voted on it. And they turned it down. So, same process. The people sent more suggestions to the committee. The committee made changes. They reiterated. They sent new copies to the towns. They discussed it. And the third time was the charm. So our Constitution was read by ordinary people, was voted on by ordinary people. It does not contain weird, obscure language that only judges can understand. The second notion that's in the Claremont decision is that the word cherish itself had sort of an obscure 18th century meaning that is different than our meaning today, right? Because today we would just think, okay, we're going to encourage or like or support or something like that. But that the meaning was specifically, must pay for. And that is not true either. So my authority for this is the gentleman standing behind me here. And I don't mean our clerk or you, Mr. Speaker, I mean George Washington. Okay? So George Washington served as president for 8 years, and his most famous speech is his farewell address in 1796. And in that farewell address, he happened to use the word cherish 3 times. And I would submit to you, he used it exactly as we would today. He said that we should cherish our national union. He said that we should cherish religion and morality. And he said that we should cherish the public credit, right? So we shouldn't borrow too much money. Unfortunately, we haven't listened to him, but, you know. All right. So the Supreme Court made a big deal of looking up the word cherish in a 1784 dictionary, and they found it to say to support, to shelter, to nurse up. Well, you could maybe think of nursing up. That might include some paying for, right? But the problem is the next line in the dictionary defines cherisher as an encourager or a supporter, right? So now we're thinking about people who like the Patriots or something like that, right? And the following word was similar. Cherishment means encouragement, support, comfort. It doesn't really mean pay for. Okay. And then their further step of saying how much we had to pay, that we had to fully pay, that's just glossed over in the Claremont decision. Okay. And then the obvious question is, if we interpret cherish literature, sciences, all seminaries and public schools as meaning send a defined amount of money to schools, the obvious question is, where are the checks for authors and scientists and seminaries, right? That's somehow ignored by the Supreme Court. And then finally, there's the original Part 1, Article 6 of the Constitution that was in it at the same time as this phrase. And that one says that the people empower the legislature to authorize the several towns to make adequate provision at their own expense for the support and maintenance of public Protestant teachers. Okay? So we are authorized, at that time, we were authorized to have towns give money at their own expense. And to further that was the fact that for the first 50 years that the Constitution was in effect, the legislature sent 0 to towns for schools. All right. So now that we know that the Claremont decision was incorrect, why should we do anything about it now, right? We've lived with it for 30 years. We are certainly going to keep supporting schools, right? So what's the urgency? The question is not whether we're going to support schools, but how and how much. That's ultimately a legislative decision, not a judicial one. Over the years, the state has supported schools by filling in the gaps that occur between poorer and wealthier communities. That's why a city like Berlin gets $11,000 a kid, and a town like Newcastle gets essentially nothing. All right? So these are inherently political decisions which should be left up to the 425 elected officials in this body, as well as the one across the hall and the governor, and not unelected and unaccountable judges. Now, last year there was a court case called Conval, and the judge in the Conval case told the state that we must spend a lot more money on education, in particular, roughly $500 million more. That the state must send that amount of money more to the public schools. Now, we can do that, actually. It's not that difficult. We could put in a 150% increase in the statewide education property tax. All right? What that would do is shift money around. Just like we do every year in the budget, when we make changes to the adequate education formula, we move money around and we create winners and we create losers. Doing this will, among the winners, be suburbs that have a lot of kids, wealthier suburbs that have a lot of kids, such as Bedford and Bow, for example. Those are the kind of towns that'll be winners under the Supreme Court's Conval decision. And one other group that will be winners that might surprise you is charter schools and EFAs. Under the Supreme Court's formula, actually not the Supreme Court yet, right? This is a lower level judge. But under the Conval formula, charter schools and EFAs will get an extra $3,200 a kid, right? So EFAs will go up by 50% and charter schools less than that. But I'm sure that not everyone in this body would like that outcome. So please, let's overturn this ITL motion and vote for bringing back these kind of decisions into the legislature where they belong. Thank you, Mr. Speaker.
Representative Marjorie Smith is recognized to speak for the committee report.
Thank you, Mr. Speaker. The distinguished gentleman from Epsom made a speech that I do not disagree with at all. He talked about his concerns about several decisions made by the judicial branch that he believes do not reflect certainly his values and those of other people who share those values. And that is a legitimate, respectable position. In fact, the amendment, however, is perhaps a little too clever by half. The amendment changes nothing. To say Cherish should be supplanted by Cherish does not inform this legislature or inform the public that would have to vote on this that what the sponsor envisioned is that therefore the legislature would no longer have to deal with court involvement in deciding how much the state should pay for education. If in fact the Judiciary Committee had before it an amendment which said, let's get the courts out of their long-term responsibilities under the Constitution and leave education strictly to the legislative branch. Some people would support that, some people would not, but they would know what the issue is. To substitute the word cherish, according to a 1784 dictionary, for the 2024 Merriam-Webster does not make that issue clear. And for all of us who respect the Constitution and take it seriously, if we want to make a change, we ought to be clear what that change is. And therefore, on behalf of 16 members of the Judiciary Committee, I hope that you will support our position to ITL this constitutional amendment, and in the fullness of time, we will again and again and again revisit how we fund education, but we will do it by saying what we're really doing. Thank you very much, Mr. Speaker.
The questions on the motion, the committee report of inexpedient to legislate. Representative Dan McGuire requests a roll call. Is that sufficiently seconded? That is sufficiently seconded. This will be a roll call vote. Members, take your seats. The question is the Majority Committee report of inexpedient to legislate on CACR 12. Representative Ammon is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if I know that CACR 12 seeks to amend a judicial misinterpretation regarding education funding to better align with the framer's actual intent, and if I know the critical role of the term cherish in our foundational documents and its problematic interpretation in the 1990s Claremont decision, in which the state Supreme Court legislated from the bench and used this word to justify a departure from 2 centuries-old practice of educational funding. And if I know that the necessity of reinstating this legislature's authority to make sane budgetary decisions, that we need to correct this error to avoid fiscal policies that would require potentially new broad-based taxes, and if I know that passing this amendment would allow this body and the citizenry at large to inform the judicial branch about the correct interpretation of the word cherish, would I now press the red button to defeat the ITL motion so that a better motion could be made? Thank you.
Representative Devine is recognized for parliamentary inquiry.
Mr. Speaker, if I understand correctly, the proposed CACR 12, which seeks to replace the 1784 word cherish with the 2024 word cherish in Article 83 of the New Hampshire Constitution, when there's nothing wrong with the word cherish, doesn't that raise a red flag that undermines the word cherish's meaning? If I know that quibbling over semantics, although may seem trivial, but altering the language of the Constitution in such a cutesy manner diminishes the Constitution's significance, and if I know the difference between words like cherish as used in Article 83 implies a solemn duty and obligation of the state government to support public education, whereas the word encouraged is used in Article 83 suggests a less binding commitment to private institutions. And if I know this semantic shift could have far-reaching implications for the state's responsibility towards funding public education and the principles upheld by long-standing legal precedents, such as the Claremont ruling. And then, furthermore, if I know that this could potentially open the floodgates of other CACR amendments to be used as a tool to alter language in the Constitution. And lastly, if I know CACR 12 does not uphold the integrity of the democratic process or protect the principles enshrined in the New Hampshire Constitution, and at its root, it seems like some bull sugar honey iced tea, then would I press the green button to ITL this bill so that we, the people in New Hampshire, are not burdened with voting on this matter? And oh, Mr. Speaker Standen, if I may encourage you to push the green button along with me to preserve and cherish, I would really appreciate your vote, and I'd cherish it.
I'm going to start counting if I knows from now on. The question is the Majority Committee report of inexpedient to legislate on CACR 12. This is a roll call vote. If you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds.
Representative Hicks. Representative Munns. Representative Yokella.
Have all members present had an opportunity to vote? The House will attend to the state of the vote. 188 in the affirmative, 177 in negative. The report is adopted.
I'll try my best while Steve takes a quick break. The Committee on Judiciary, to which was referred House Bill 1037 relative to repealing limited liability for manufacturers, distributors, dealers, or imports of firearms or ammunition. Marjorie Smith moves. Marjorie Smith moves. Representative Smith moves interim study. For what reason does it memorize?
To make a motion.
State your motion.
I move indefinitely postpone on HB 1037.
Representative Houle has requested a roll call. Is that sufficiently seconded? It is sufficiently seconded. This will be a roll call vote. Members, take your seats.
First.
The motion before us on House Bill 1037 is indefinite postponement. This is going to be a roll call vote. Chair recognizes Representative Alexander for a parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if I know we have a lot to get through today, and I know this is an anti-Second Amendment bill and would completely destroy the gun manufacturing in the state, would I then press the green button? Thank you.
Chair recognizes Representative Marjorie Smith for a parliamentary inquiry.
Thank you, Mr. Speaker. If you know that this is an issue that is of incredible importance to the New Hampshire legislature, that has focused always on the rights of gun manufacturers and recognizing how important so many members of the body believe that to be, if you want to make sure that serious consideration is given to these issues so that we can have a position that is acceptable to everybody, would you vote no on indefinite postponement so that the committee we could discuss this bill, and if you support the committee would then work on interim study to try to resolve some of these issues. Thank you.
The motion before us on House Bill 1037 is indefinite postponement. This is a roll call vote. If you're in favor, you'll press the green button. If you're opposed, you'll press the red button. Voting stations are open for 30 seconds. I'll try getting closer to the microphone. Have all members present had the opportunity to vote? House will obtain the state of the vote. 196 voting yea, 163 voting nay. Indefinite postponement passes. The Committee on Judiciary, to which was referred House Bill 1089, an act relative to statute of limitations on civil actions involving PFAS, considered the same, report the same, with a recommendation that the bill be referred for interim study. Senator Marjorie Smith for the committee. Are you ready for the question? All those in favor say aye. Aye. Those opposed, nay. The ayes have it, and the interim study passes. Majority of the Committee on Judiciary, to which was referred House Bill 1220 FN, act relative to abolishing the collection of racial and ancestral data for use in marital application worksheet, considered the same, report the same, with the following amendment. The recommendation the bill ought to pass with amendment. Representative Ben Bing for the majority of the committee. Minority of the committee, having considered the same and being unable to agree with the majority, report with the following resolution. Resolve that it's inexpedient to legislate. Representative Christine Perez for the minority of the committee. The committee amendment is 0415H, printed in House Record 9, page 61. The motion is on the committee amendment. Are you ready for the question? All those in favor say aye. Aye. Those opposed, nay. The ayes have it, and the committee amendment is adopted. The bill's on second reading, open to further amendment. Representative Perez offers floor amendment 0793H, printed in House Record 9, pages 61 to 62, and recognized to speak to her amendment.
Thank you, Mr. Speaker. First of all, the marriage application does not require this information. The only information that the marriage application requires is your name, your residence, your date of birth, your social security number, your mother's maiden name, your father's maiden name. It doesn't require any of these things. The amendment, which eliminates this, eliminates ancestry. It moves our personal history, the origin of your family, the line of your descent. It prevents future generations to view their history. Names may change, but your lineage does not. Future generations might also want to obtain this information because it might be valuable in the future for perhaps medical information or medical studies that come down the line. Now, my name is Christine Perez. Would you ever think that I am first generation Italian? But I am. Thank you.
The motion before us is the Perez floor.
So we've had a request for a division.
There has been a request for a division on the amendment. Members, take your seats.
does change the title of the bill, so that is different in that it is.
Representative Lynn. Go back to your seat. We're in the voting mode.
Members should be in their seats. So what's going on?
Representative Mayne, you should go back to your seat.
The amendment that she has, it doesn't change it. It does change the title.
Why are these people standing up?
We're in the voting mode. Let's find our seats.
Down. Representative Weber, Representative Lynn, please take your seats. We're in the voting mode.
Representative Marjorie Smith, do you have a parliamentary inquiry?
Thank you very much, Mr. Speaker, and I would like to begin my parliamentary inquiry first by announcing how pleased I am that you're there rather than the Speaker, whose voice should not be strained. So glad you're there. If you know, you're absolutely right. Thank you very much. I'm glad for that advice. If I know, as I do, that the body of this amendment is exactly the same as the body of the amendment that you just voted on, and the only difference between the two amendments is a change in the statement of purpose, the title of the amendment, would you then join the majority of the Judiciary Committee that supported the First Amendment and support this amendment too? Thank you.
Representative
Thank you.
Perez is recognized for parliamentary inquiry.
If I know in your calendar the bill, the amendment, was misrepresented, and it said that my amendment crossed out the word ancestry, and I know that that was a mistake done in the calendar, and if I know my bill, my amendment allows for ancestry to be kept on the information that you may fill out on your application, then I would vote green, push the green button to pass this amendment.
All right, then. The question is whether to adopt floor amendment 0793H. If you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds.
The way it was drafted is exactly the way it is in town. Bellberger.
Have all members present had an opportunity to vote? The House will attend to the state of the vote. 324 in the affirmative, 33 in the negative. The amendment's adopted. Point of clarification. The chair recognizes the clerk.
Thank you, Mr. Speaker. Just to correct the understanding, the amendment as printed on page 61 and 62 of your House calendar is exactly as drafted by the Office of Legislative Services and does strike out their race and ancestry and level of education. So the amendment that you just voted does do the same thing as the majority amendment.
And now we're on to the main motion of OTPA as amended. Representative Perez is recognized to speak against the committee report. Representative Christine Perez.
Thank you, Mr. Speaker. There is no reason to remove this information from the application. It is not required information. It is voluntary information. So why remove it? Why have to pay to change all the applications that come out in the future? Leave it the way it is and let people who want to research their ancestry in the future the ability to do that. Thank you. I would vote no. I would push the red button on ought to pass.
Representative Mings recognized to speak for the committee report.
Thank you, Mr. Speaker. The state of New Hampshire currently asks for race and ancestry data on its marriage applications. There we go. How's this? All right. Okay. Any couple going to their local clerk's office is asked to provide this information as part of the process for receiving a marriage license. Although the paperwork connecting a person to their race is ultimately destroyed after the data is collected and the marriage license is issued, there's still a significant problem. HB 1220 would remove this unconstitutional requirement. The governor singled out this very issue 4 years ago in a letter to the House Speaker and the President of the other body, urging them to find a legislative solution for this issue out of a more expansive bill. The interest that the Attorney General's office had in now revisiting this idea came about because it not only believes this is still a problem to be addressed in New Hampshire, it is also aware of successful efforts to remove similar data collection requirements in other state courts. The primary reason to halt this practice, above all else, is to protect access to marriage. Marriage is not simply an institution of belief, it is a fundamental right. Those cases in other states won on the argument that the requirement to provide race and ancestry data would discourage certain couples from marrying. More specifically, it was determined to be a restriction of a fundamental right, with the law worthy of being assessed under the standard of strict scrutiny, the highest level of constitutional review by our court system. The only way a law is allowed to impede the right to marry is the identification of a compelling governmental interest, and the state of New Hampshire doesn't have one. The Attorney General's office has worked with the Division of Vital Records, who shared that this data is not used for any reason other than to just retain it, and it's mostly duplicative of US Census data. I encourage you to vote green on the motion of ought to pass as amended, because a vote in favor of HB 1220 is a vote to correct the unconstitutional collection of race and ancestry data and to protect the fundamental right of marriage. Thank you, Mr. Speaker, and I request a division vote.
The question is on the committee report about to pass as amended. This is a division vote. Members, take your seats. The question is on the Majority Committee report about to pass as amended. Representative Christine Perez is recognized for parliamentary inquiry. She's waving off. Would you like to? You going to go anyway? Representative Marjorie Smith's recognized for parliamentary inquiry.
Thank you, Mr. Speaker. If I know that this legislation was requested by the Attorney General's office in order to have New Hampshire conform with federal law, and that this legislation helps to support this legislature's strong belief in the importance of marriage and family, would you now join the overwhelming majority of the Judiciary Committee by voting OTPA? Thank you.
The question is the Majority Committee report about to pass as amended on House Bill 1220. This is a division vote. If you're in favor, press the green button. If you're opposed, press the red. Voting stations are open for 30 seconds. Have all members present had an opportunity to vote? The House will attend to the state of the vote. 293 in the affirmative, 64 in the negative. The report is adopted. The Committee on Judiciary, to which was referred House Bill 1412 FN relative to court reporters, sends it to us without recommendation. Representative Lynn moves ought to pass. The floor amendment is 0901H, which can be found in your seat pockets. There he is. Representative Lynn is recognized to speak to his motion.
Colleagues, on this motion, the amendment, the only thing that it does is change the effective date of this bill, if it passes, from 60 days to 90 days. This was a request made after the hearing by one of the court reporter representatives, and I told the court reporter representative that I would draft such an amendment for our executive session. And I did have it drafted, And we were so busy at the executive session that, frankly, I forgot to offer the amendment. I really felt badly about that because I made a commitment to this person that I would do it. It's a perfectly reasonable request if the bill passes. So I know we're going to have a debate on the bill itself, but I hope everyone will be able to agree that this amendment is entirely appropriate, and I urge you to vote in favor of the amendment.
The question's on the adoption of Amendment 0901H. Are you ready for the question? All those in favor say aye. Aye. All those opposed, nay. The ayes have it, and the amendment's adopted. Now the question is the main motion of ought to pass as amended. Representative Marjorie Smith is recognized to speak against the motion.
Mr. Speaker, this is not the first time we have seen this language. The language was initially proposed in House Bill 2 last year when there was a determined effort to cut down dramatically the licensing and regulation of many entities in the state. It was pulled out of HB2, and it's now here as part of an effort on a case-by-case basis to deregulate licensing. And so you have to understand this is not a new issue, but it's a very important issue. I was privileged to be named by the Speaker to serve on a special committee on the family court. And we worked very hard over the last year or so, looking at what was happening in the family court, listening to people who had some concerns, and trying to evaluate those concerns. One part of that review that I must say gave me absolutely no pleasure was to read transcripts that had been prepared in the family court. Transcripts that were full of errors, omissions, confusion, that not only meant that there was not an accurate record, as you know, my mother taught me never to speak when others were speaking, so I'm just waiting for the doors to close. It was not only an injustice, perhaps, for those people who were in the courts, but for those of us who are charged with evaluating what goes on in those courts. Those transcripts were not written by court reporters because several years ago, the courts generally acted to remove court reporters and instead to use recording devices, which someone or other was responsible for turning on at the start and one hopes turning off at the end of a court day. Sometimes that works, sometimes that doesn't. But that's the court's problem. The court has to make those decisions for themselves. However, court reporters have a lot of other responsibilities, and they are trained, they are evaluated, they are licensed, they have continuing education requirements, they take depositions for legal proceedings, they do all kinds of things that determine, in fact, at the end, the quality of the judicial process. And it is because of that that the committee, that half of the committee, it was 10-10, believed that in fact court reporters do continue to provide an important function with high standards, and it was something that we ought to protect, not for particularly for our benefit, but for the benefit of the citizens who are in situations that involve the need for an accurate record of what is going on. Therefore, we would ask that you vote against the bill, which would mean supporting the the ITL motion that was supported by 10 of the committee members, and hope you will do that in the best interest of the quality of the work we need from people who carry out this essential function. Thank you.
Representative Lynn's recognized to speak in support of the motion.
Thank you, Mr. Speaker. Mr. Speaker, when this bill was first in committee, our Speaker Emeritus from Concord, a person who I have known and greatly respected for more than 40 years, testified against the bill. He related the great respect he had for court reporters based on his experience observing them in court when he was with the United States Marshal's Office, and he said ending state regulation of them would threaten the accuracy and integrity of crucially important court records. 20 years ago, I could not have agreed more strongly with the views he expressed. At that time, the Superior Court, where I was a judge, exclusively used court reporters to make the verbatim stenographic records of trials and hearings. But at about that time, as a money-saving move, the Supreme Court decided to terminate the court reporters and replace them with a tape recording system that would record all proceedings and would be operated by a much lower paid person called a monitor, whose job would be to make sure that recording devices were working properly and to collect and mark exhibits, etc. Most of us judges on the Superior Court at this time, myself included, were strongly opposed to terminating the court reporters because, just like the Speaker Emeritus, we believe doing so would be a disaster in terms of the accuracy and integrity of the record of court proceedings. And candidly, beyond our professional concerns, we trial judges had great affection for our court reporters. They were part of our court family, and we didn't want to see them terminated. The whole thing got very ugly. The court reporters unionized. They filed a lawsuit trying to prevent their discharge. The case went to the Supreme Court, where most of the judges recused themselves, and a number of retired Superior Court judges were substituted in their place. And eventually, in a 3-2 decision, the court upheld the termination of the court reporters. But as it turned out, I was wrong. Over the past 20 years, the tape recording system implemented by the Supreme Court has worked just fine. Have there been a few problems occasionally from time to time? Yes, but there were a few problems with the court reporters. And it did save the state a great deal of money. The recording devices work well, and when a transcript is needed, the court system uses an outfit in Arizona to which the recordings have been sent for years to prepare the written transcripts. The point of all this is that although they are still called court reporters, they could more accurately be called non-court reporters because they no longer are used in the state court system. Their work today consists mostly of making a stenographic record of depositions and other out-of-court proceedings where a verbatim record is needed. The arguments offered now for why court reporters should be regulated by the state, the need to ensure accuracy and integrity of the testimonial record, are exactly the same arguments that were made 20 years ago for not terminating their positions in the court. Those arguments turned out to be wrong then, and they are wrong now. State regulation of court reporters is unnecessary. In the 17 years that the court licensing system has been in effect, there has never been an enforcement or disciplinary proceeding involving a court reporter. The current scheme requires court reporters to be licensed, which in turn requires that they hold certification from one of the two national credentialing bodies, and that they comply with a code of ethics and continuing education requirement issued by these bodies. Licenses must be renewed licenses must be renewed every 2 years, and court reporters also must be bonded in the amount of $1,000. All of these requirements have costs and fees associated with them. Please understand, as proponents of deregulation, we do not suggest that credentialing by the national associations or continuing education or bonding are bad things. We simply say that there is no reason for the state to be involved in any of this. The people who use court reporters are a sophisticated group. They are mostly attorneys or other professionals. If they want a court reporter who has the national credential or the continuing education or the bonding, they can make any or all of these things conditions of hiring the court reporter for a particular job. In short, this is something that the marketplace can handle. The only real effect of licensing is to limit competition in this field. Under the law, no one can engage in stenographic or a similar type of court reporting without a license. To do so is a crime. The license is time-consuming and relatively expensive to obtain. Moreover, although the need for a license technically does not apply to someone who may desire to use a tape recorder to make and preserve the record, the statutory prohibition against using these terms, quote, court reporter, court recorder, verbatim reporter, verbatim court reporter, or verbatim court recorder, make it very difficult for someone desiring to use this method to advertise the availability of their services in a meaningful way to those who might be interested in marketing them. There are not a great many licensed court reporters, and the cost of this regulatory scheme in the overall universe of state regulation is relatively small. But the principle at stake here is an important one. The question you must decide by your vote is this: does this legislative body have the will to reduce the size of government just a little bit, to take a baby step to reduce the state's regulatory footprint and enhance economic freedom in an area where public safety and health are not at all implicated? I submit to you respectfully, colleagues, that if we can't deregulate this industry, it's hard to imagine how we will ever be able to deregulate any industry. For these reasons, I urge you to press the green button, and Mr. Speaker, I respectfully request a division vote. Thank you.
The question's on the motion of ought to pass as amended on House Bill 1412. This will be a division vote. Members, take your seats. Representative Sweeney has requested a roll call. Is that sufficiently seconded? That is sufficiently seconded. This will be a roll call vote. Members should be in their seats. The question is on the motion of ought to pass as amended on House Bill 1412, and this is a roll call vote. Representative Grote is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if I know that the Institute for Justice, a public interest legal firm, testified before ED&A and said that New Hampshire had a light touch on licensing, a light touch. And if I know that court reporters are more dependable than technology, and also lastly, if I know that court reporters act in many environments, including but not limited to depositions and other legal proceedings, excuse me, would I not press the green button? No. Would I not press the red button? So it's been one of those days. Would I not please press the red button and defeat this motion so that another motion can be made? Thank you.
Representative Tony Lakis is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. If I know that court reporters are no longer used in the New Hampshire courts, and if I know that the professionals that hire them for out-of-court proceedings can impose similar requirements when hiring them as licensing currently does if they wish, or use other methods to record proceedings. And if I know that this license does nothing to protect the health and safety of the public, which is the legitimate purpose of occupational licensing, would I then press the green button to support the OTPA motion to eliminate this burdensome and outmoded license? Thank you, Mr. Speaker.
Questions on the motion of ought to pass as amended on House Bill 1412, and this is a roll call vote. If you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds. Have all members present had an opportunity to vote? The House will attend to the state of the vote. 188 in the affirmative, 166 in the negative. The motion is adopted. Before we move on, somebody pointed something out to me that was a really good point. When you move for there to be a roll call, and then I ask if it's sufficiently seconded, you should not stand up because you should not second your own motion. Let your friends do that. The Committee on Legislative Administration, to which is referred House Bill 1629 FN, relative to Attorney General's duties concerning legislators residing in different districts than they represent, comes to us without recommendation. For what reason does the member rise?
For a motion, Mr. Speaker.
Please state your motion.
Mr. Speaker, I move that we lay House Bill 1629 on the table.
Representative Weber.
And I request a division vote.
I'm sorry?
And I request a division vote.
Okay. Representative Weber moves that we lay House Bill 1629 on the table. This will be a division vote. Members, take your seats. The motion is whether to lay House Bill 1629 on the table. Representative Weber is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if I know that House Bill 1629 was filed to establish a transparent notification process regarding the residency violation of legislators, and if I now understand that the Attorney General has notified the Speaker and the Minority Leader to inform them that the Department of Justice has established a new protocol to ensure investigatory information regarding the residency of sitting legislators is shared with both parties, would I now press the green button to support the motion to lay House Bill 1629 on the table? Thank you, Mr. Speaker.
The question is whether to lay House Bill 1629 on the table. This is a division vote. If you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds.
Representative Sychterz.
Have all members present had an opportunity to vote? The House will attend to the state of the vote. 339 in the affirmative, 19 in the negative. House Bill 1629 is laid on the table. The majority of the Committee on Legislative Administration, to which was referred H.R. 29, an act declaring an economic justice Bill of Rights, having considered the same, report the same with the following resolution: resolved that it is inexpedient to legislate. Representative Stephen Pearson for the majority of the committee. The minority of the committee, having considered the same and being unable to agree with the majority, report with the recommendation that the bill be referred for interim study. Representative Janet Wall for the minority of the committee. The questions on the majority committee report of inexpedient to legislate. Are you ready for the question? All those in favor say aye. Aye. All those opposed, nay. No. The ayes have it, and the report is adopted. The majority of the Committee on Municipal and County Government, to which was referred House Bill 1086, an act relative to public notice of Zoning Board of Adjustment hearings, having considered the same, report the same with the following resolution: resolved that it is inexpedient to legislate. Representative Diane Power from the majority of the committee. The minority of the committee, having considered the same and being unable to agree with the majority, report with the recommendation that the bill ought to pass. Representative Jim Maggiore from the minority of the committee. The questions on the majority committee report of inexpedient to legislate. Are you ready for the question? All those in favor say aye. Aye. All those opposed, nay. The ayes have it, and the report is adopted. The majority of the Committee on Municipal and County Government, to which was referred House Bill 1120, an act repealing the provision that requires the reflection of municipal body votes on warrant articles. Having considered the same, report the same with the following resolution: resolved that it is inexpedient to legislate. Representative Richard Brown for the majority of the committee. The minority of the committee, having considered the same and being unable to agree with the majority, report with the recommendation that the bill ought to pass. Representative Josh Ukella from the minority of the committee. Representative Dunn is recognized to speak against the committee report.
Thank you, Mr. Speaker. Good afternoon, fellow representatives. On March 12th, it's town meeting day for most of us in this chamber. This is where we go to the polls and we vote on warrant articles. These warrant articles are currently, by state law, are mandated to have the Budget Committee, the Town Council, or the Select Boards vote on those ballots. It's required to be printed on there. If we decide to overturn this ITL and make another motion, all this bill would do is remove the RSA that says that these votes are not printed on the ballot. Printing the votes on the ballot is electioneering. This bill would remove the votes from being printed on the ballot. This bill does not remove the ability of the municipal bodies to vote on the warrant articles. It would only remove the votes from being printed on the ballots. Municipal bodies can still vote on the warrant articles. The public will still know the opinions of the municipal bodies, but they will not be printed on the ballot. This bill will stop electioneering in the ballot booth. I am not allowed to walk in to the ballot location with a hat, a pin, a sticker, or a sign that says vote yes on 3. However, my vote as a town councilor is on that ballot, and I submit to you that my vote has more power on that ballot than any hat, sticker, pin, or sign you'd walk into the ballot booth with. Voter X walks into the ballot booth. They get their ballot. They go into the ballot booth. They don't know what warrant Article 3 is about, but they see the very last thing they read, oh, my counselor, Ron Dunn, he voted for this. I'm going to vote for it. How's that any different than me standing right next to Voter X saying, vote for this? It's electioneering. I'm there in the ballot booth with them. My vote is on that ballot. My vote is the last thing the voter is going to read. This being printed on the ballot has more influence over the voter than anything we currently classify as electioneering. I ask you vote no on the ITL so another motion can be made. Mr. Speaker, I ask for a division vote. Thank you.
Representative Richard Brown is recognized to speak for the committee report.
Thank you, Mr. Speaker. Thank you, fellow representatives. Many voters who attend town meetings do not have the ability to attend governing body meetings or the time to review those meetings online, but do want to know how their members voted. After all, they voted for them to do the community work and want to know how they voted on important issues. In many cases, I feel the officials have expertise and time to investigate these matters that they can't. And in most instances, people trust them, but also want to confirm that their officials are accountable to them. When the members' vote tally is shown along with the warrant articles, people can see several things. For instance, if it's a 4-0 vote, it could give voters confidence in the article's validity. If it's a split vote, 2-2, for instance, it would likely bring people to question it. If it's 0-4, it would likely be a serious consideration for them to examine. In any case, it gives people additional information, a more informed vote. From my experience, it also typically prompts questions from voters. Who voted which way and why is what they want to know. In the House, we have majority and minority reports. We also have white sheets, gold sheets, pink sheets, and whatever information people hand to us as we enter the House. I always look at the majority and minority reports and look at how the vote is split. I always look at this to help determine how hard I should look at an issue. In all cases, I want to know how the committee voted, what the numbers were. I can't possibly attend all the hearings in the House, just as residents can't or don't have the time to attend or view all the meetings that they would like to. Not showing the governing body vote count limits voter information for no good reason and may imply that since the article is presented, everyone supports it. We want informed voters. Please support ITL and don't remove information that many voters use to make good decisions. Vote green to ITL this unnecessary change to existing law. Thank you.
The question is on the Majority Committee report of inexpedient to legislate. Are you ready for the question? All those in favor say aye. Aye. All those opposed, nay. No. The ayes have it, and the committee report's adopted. He asked for a division during his speech, so we're going to do a division vote. No?
Ask because you've stated the vote.
Yeah, somebody has to move reconsideration.
I'm used to it, so.
A pro.
Having voting on the prevailing side, I would move reconsideration on HB 1120, and I would urge the body to vote yes. Voice vote.
The question is whether to reconsider the previous vote on House Bill 1120. Are you ready for the question? All those in favor say, what, really? Okay, I guess this will be a division vote too. Question is whether to reconsider the previous vote on House Bill 1120. Representative Sweeney is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if I know the member had previously asked for a division vote on this bill, and Mr. Speaker, if I know that was not heard, but further, Mr. Speaker, if I know that we've been very accommodating today on various motions to have votes on bills other times, would I now vote yes for reconsideration so that the underlying motion can be voted on again via a division vote? Thank you.
The question is whether to reconsider House Bill 1120. This is a division vote. If you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds.
Representative Aaron.
Have all members present had an opportunity to vote? The House will attend to the state of the vote. 188 in the affirmative, 168 in the negative. Reconsideration passes. We are now back to inexpedient to legislate, and this will also be a division vote. Representative Cordelli requests a roll call. Is that sufficiently seconded? It is sufficiently seconded. This will be a roll call vote. Members, take your seats. The question is the motion of inexpedient to legislate on House Bill 1120. Representative Christine Perez is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if I know that printing the vote of the municipal body on the ballot is electioneering, and Mr. Speaker, if I know that this is the last thing voters read before casting their vote, and Mr. Speaker, if I know that the vote of a selectman or a budget committee member has more power and influence than any hat, pin, sticker, or sign, would I now press the red button to overturn the ITL so a better motion can be made? Thank you.
Representative Brown is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. If I know that most voters do not attend select board or school board meetings, and if I know that most voters value their elected officials' positions and opinions, And Mr. Speaker, if I also know that this information initiates thoughtful discussion around warrant articles, then would I now press the green button to ensure that this simple, already available information remains listed on the warrant articles? Thank you, Mr. Speaker.
The question is the motion of inexpedient to legislate on House Bill 1120. This is a roll call vote. If you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds.
Representative Elberger. Representative Boschman.
Have all members present had an opportunity to vote? The House will attend to the state of the vote. Choose 64 in the affirmative, 95 in the negative. The motion is adopted. The majority of the Committee on Municipal and County Government, to which was referred House Bill 1125, an act relative to requiring public notice and comment at all county commissioner and delegation meetings. Having considered the same, report the same with the following amendment and the recommendation that the bill ought to pass with amendment. Representative Laurel Stavis for the majority of the committee. The minority of the committee, having considered the same and being unable to agree with the majority, report with the following resolution: resolved that it is inexpedient to legislate. Representative Josh Giocella for the minority of the committee. The committee amendment is 0784H, printed in House Record 9 on page 52. The questions on the adoption of the amendment. Are you ready for the question? All those in favor say aye. Aye. All those opposed, nay. The ayes have it, and the amendment's adopted. The bill's on second reading and open to further amendment. Representative Stavis offers floor amendment 0854H, printed on House Record 9 on page 52, and is recognized to speak to her motion.
Thank you, Mr. Speaker. Mr. Speaker, I'm introducing this floor amendment today to correct a drafting error in the original. It simply deletes wording in a previous amendment that restricted public participation in county commission meetings to comment only and not to questions. The floor amendment before you today removes a sentence that prohibited county residents from asking questions during the meeting, and the members of municipal and county government view the ability to ask questions as vital to the openness and accountability called for in RSA 91A. They were rightly insistent this sentence be removed. This amendment accomplishes that, making the underlying bill even stronger. I urge you to join the majority of municipal and county government in voting to adopt it. Thank you, Mr. Speaker.
The question's on the adoption of floor amendment 0854H. Are you ready for the question? All those in favor say aye. Aye. All those opposed, nay. The ayes have it, and the amendment's adopted. Now we're on to the main motion of ought to pass as amended. Are you ready for the question? All those in favor say aye. Aye. All those opposed, nay. The ayes have it, and the motion's adopted. The majority of the Committee on Municipal and County Government, to which was referred House Bill 1242, an act relative to the establishment of county-wide communication districts. Having considered the same, report the same with the following resolution: resolved that it is inexpedient to legislate. Representative Diane Power for the majority of the committee. The minority of the committee, having considered the same and being unable to agree with the majority, report with the recommendation that the bill ought to pass. Representative Jim Maggiore for the minority of the committee. Representative Howard is recognized to speak against the committee report.
Thank you, Mr. Speaker and honorable representatives. HB 1242 is all about governmental efficiency in establishing communications districts so we can best use the unprecedented broadband funding being made available by the Biden administration. Our state's rural communities have struggled to access this great program that started in 2020, with only a couple districts being formed since, despite the connectivity issues our rural communities continue to face. The major problem is with how we currently establish districts, because it is individual towns starting this process, but the economies of scale work better at the county level. Communications districts are not tax funded, but are funded by subscribers, and ensuring a large enough subscriber base means operating at a county level. That is why one of the few districts in the whole state is the Carroll County Communications District, because it is operating at an appropriate scale despite the tedious and difficult establishment process. Opponents of this bill have claimed that counties already have this power, which is false because the bill explicitly refers to RSA 21, 47, and 48, which explicitly only gives county governments the power over unincorporated towns and not the whole county. This is only enabling legislation, meaning that counties are not forced to create a communications district, but if they do, municipalities still have the option to opt out. The Association of Counties is in unanimous support of this legislation, and I will hope you will join me in helping our rural communities in North Country have quality internet access by streamlining this existing statute. Thank you.
Representative McDonald is recognized to speak for the committee report.
Thank you, Mr. Speaker. HB 1242 is the establishment of county-wide communication districts. This bill, if passed, would allow a county-wide community districts. But it's going to do is it's going to demand and involuntarily require all the communities within that county to join that district. They will have the option to opt out, but they still have to do that on their own. The governing body of the municipality would be taxed with taking the extra step to change and get out of the county agreement. The majority of the committee believes this bill is unnecessary, as current law allows 2 or more municipalities to create a communication district. A prime example of that is the Carroll County Communication District, in which 16 towns have come together to create the district. It is working both effectively, fairly, and evenly for all its members. I urge you to support the majority position of ITL. Thank you.
The questions on the majority committee report of inexpedient to legislate, and a division vote has been requested. This will be a division vote. Members, take your seats. The questions on the majority committee report of inexpedient to legislate on House Bill 1242. Representative Representative Maggiore is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if I know broadband applications are so wide-ranging, they touch every social determinant, including economic stability, education, social supports, and civic activity, and if I know expanding our communication district statute to include counties as well as municipalities will increase sharing of planning, construction, operating, and maintenance of broadband services, equipment, and infrastructure for residential and commercial customers alike. And if I know public-private partnerships between counties and broadband service providers will increase access to service that may reduce customer costs. And if I know that this is only enabling legislation that municipalities may opt out of if they choose, then, Mr. Speaker, would I press the red button to overturn this motion so that a motion to pass this legislation can be made? Thank you, Mr. Speaker.
Representative Len Turcotte's recognized for a parliamentary inquiry.
Thank you, Mr. Speaker. If I know municipalities within a county already have the ability to create communications districts, and if I also know this bill would allow county commissioners to unilaterally impose communication districts countywide, if I know this bill would force municipalities to have to opt out of a communication district rather than opt in, and finally, if I know that communications districts should be created from the bottom up rather than utilizing top-down mandated schemes, would I now press the green button to support the majority position of ITL? Thank you, Mr. Speaker.
The questions on the majority committee report have been expedient to legislate, and this is a division vote. If you're in favor, press the green button. If you're opposed, press the red. Voting stations are open for 30 seconds.
Representative Gibbs.
Have all members present had an opportunity to vote? The House will attend to the state of the vote. 173 in the affirmative, 172 in the negative. The report is adopted. I voted on that. The Committee on Municipal and County Government, to which was referred House Bill 1297-FN, an act relative to the authority of municipalities to enforce ordinances related to health and safety. Having considered the same, report the same with the following resolution: resolved that it is inexpedient to legislate. Representative Len Turcotte for the committee. For what reason does the member rise?
To make a motion, Mr. Speaker.
State your motion.
A motion to table HB 1297.
Representative Len Turcotte moves that House Bill 1297 be laid on the table. Are you ready for the question? All those in favor say aye. Aye. Hold up.
Hold on. She had said division. Representative McWilliams had said
Division. Members take your seats. question is whether to lay House Bill 1297 on the table. Representative Len Turcott recognized for parliamentary inquiry.
Thank you, Mr. Speaker. If I know each municipality has developed their own specific zoning regulations over many decades to suit each municipality's needs, and if I also know this legislation would completely negate and upend those decades of zoning regulations of every municipality within our state, would I now press the green button to support the large 16-3 bipartisan majority vote of inexpedient to legislate? Thank you, Mr. Speaker. To table. Thank you.
Representative McWilliams is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if I know that New Hampshire is currently in the midst of a housing crisis where the median down payment of 20% to buy a single-family home in the Granite State is $71,500, according to Bankrate.com, and if I further know that we are struggling under the burden of 50 years of NIMBY local ordinances, many designed with the intent to keep out new home buyers and block residential development. And if I know that according to the Mercatus Center at George Mason University, quote, New Hampshire only permits about 3 new dwellings per year per 1,000 residents. Further, quote, local authority to regulate housing density is based on the state-granted power to protect the health and safety of residents. But localities in New Hampshire have imposed restrictions on new development that go far beyond these well-defined concerns and have left the market unable to respond to a growing housing shortage, end quote. And finally,
The House will be in order.
Finally, if I know that starting over with a blank slate to rewrite our zoning regulations is exactly what we need to address runaway rents and affordability for first-time homebuyers, to rewrite new rules for our rigged game of monopoly our municipalities have created through 50 years of zoning ordinance overreach, would I then press the red button and instead support a vote for new rules for new housing on behalf of future generations of Granite Staters? And Mr. Speaker, I ask for a roll call. Thank you.
We're in the voting mode, so you can't. The question is whether to lay House Bill 1297 on the table. If you are in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds. Have all members present had an opportunity to vote? The House will attend to the state of the vote. 285 in the affirmative, 65 in the negative. House Bill 1297 is laid on the table. So something happened a bunch of times today. We're going to address it. PIs. If you come up to do a PI and you got a whole page, you're not going to get through it. I will stop you, okay? Do a PI. The majority of the Committee on Municipal and County Government, to which was referred House Bill 1359, an act relative to appeals of certain zoning decisions by abutters. Having considered the same, report the same with the recommendation that the bill ought to pass. Representative Len Turcott for the majority of the committee. The minority of the committee, having considered the same and being unable to agree with the majority, report with the following resolution: resolved that it is inexpedient to legislate. Representative Diane Power for the minority of the committee. Representative Power offers floor amendment 0952H, which can be found in your seat pockets, and is recognized to speak to her motion.
Thank you, Mr. Speaker. I rise in support of the floor amendment to House Bill 1359. This floor amendment simply adds language that would allow a property owner in a municipality who is directly affected by a decision of the Board of Adjustment to be able to file an appeal at the local level. This amendment is important because the bill as written goes too far and is overly restrictive. Mr. Speaker, it is important to understand that a property owner can in fact be affected by a zoning Board of Adjustment decision while not being an abutter as defined in statute. We know that most towns in New Hampshire are entirely on private wells and septic. Consider, for example, a large subdivision that is granted a density waiver by a ZBA. And keep in mind that only abutters are notified when the ZBA cases are heard. In this example, without this floor amendment, a directly affected non-abutting property owner with demonstrable evidence that the density waiver would negatively impact the shared aquifer would not be allowed to file an appeal at the local level. However, with this floor amendment, a directly affected property owner in the municipality can file an appeal at the local level within 30 days. Since the ZBA must hold the rehearing within 30 days to consider the new information, the maximum delay is 60 days and often much less. To be clear, House Bill 1359 as written denies a non-abutting property owner who is directly affected by a board decision of their due process rights for an appeal at the local level. This leaves as the only recourse a prolonged court case in Superior Court, which will undoubtedly result in greater delays for any project and increased expense for all parties involved, including affected property owners, the developer, the municipality, and ultimately the taxpayer. Mr. Speaker, this floor amendment is a common sense provision that will protect the rights of local property owners and give them a voice for a rapid resolution at the local level. Therefore, I urge my fellow colleagues to vote yes to support this floor amendment and then the bill as amended. Thank you, Mr. Speaker.
Representative Maggiore is recognized to speak against the amendment.
Thank you, Mr. Speaker. Mr. Speaker, I rise in opposition to the floor amendment. Adopting this floor amendment would defeat the purpose of the important underlying bill. HB 1359, as it has been brought to us today, will be a major step forward in facilitating the housing our state critically needs. HB 1359 changes the wording currently in statute, which is highly subjective, to a more relevant, understandable definition of what constitutes a butter. When developers go before zoning and planning boards, they are now open to time-consuming and costly appeals from any person aggrieved, as stated in current law. I think you will agree, Mr. Speaker and colleagues, that this could mean anyone. And frequently it does, making proceeding with building projects much more costly and in many cases nearly impossible. This amendment tries to deal with the problem of changing the language to any property owner in the municipality directly affected. But the current statute's language is also vague and can be interpreted in any number of ways. What would directly affected mean? Could it mean someone 10 miles away whose morning drive would have them go one more stop or pass by the site? Could it be someone 15 miles away who has a difference of opinion with the applicant, unrelated to the application? And should the application affect an aquifer, DES points out statutes which clearly give the PUC authority to overrule any local regulation that would prevent community water systems from being squarely regulated by the state, prevent community water systems from being squarely regulated by the state alone if necessary. That provision has never been used, but it does exist. So the aquifer question is a state question, not a local question. Clearly, this amendment runs counter to the spirit and intent of 1359. It further muddies waters that are already murky at best. I urge you to defeat this amendment so we can move on to pass this important legislation, which was bipartisan from both Republicans and Democrats on our committee. Thank you, Mr. Speaker.
The questions on the adoption of floor amendment 0952H. This will be a division vote. Members, take your seats. The questions on the adoption of floor amendment 0952H. Representative Powers recognized for a parliamentary inquiry.
Thank you, Mr. Speaker. If I know that this floor amendment would simply allow a property owner in a municipality who is directly affected by a decision of the Board of Adjustment to be able to file an appeal at the local level, which would take no more than 60 days, and if I know that this floor amendment enabling appeals by aggrieved property owners will save developers, municipalities, property owners, and taxpayers alike precious time and money by minimizing court cases, would I now vote yes to support the floor amendment and push the green button? Thank you, Mr. Speaker.
Representative Maggiore is recognized for a parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if I know that directly affected is ambiguous, and we cannot fully understand who will be directly affected, then, Mr. Speaker, would I please vote no on this amendment? Thank you.
Nice PIs. The question is whether to adopt floor amendment 0952H. This is a division vote. If you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds. All members present had an opportunity to vote. The House will attend to the state of the vote. 130 in the affirmative, 224 in the negative. The amendment fails. We are now on to the main motion of ought to pass. Representative Corcoran is recognized to speak against the report.
Thank you, Mr. Thank you, Mr. Speaker. It's important to understand exactly what a zoning board of appeals does and what a planning board does. A lot of people think that the zoning board writes the zoning code. That's incorrect. The planning board does. What about it? Okay. It's important to understand what a zoning board does. A lot of people mistakenly think that it writes the zoning code. It does not. That's the planning board. The Zoning Board of Appeals has two purposes. One is to grant variances from the zoning code where justice and strict application of the letter of the law would not do justice. But the other thing is to serve as due process or to hear citizens protesting when the government has not behaved correctly or fairly. I'll give you one particular example. 6 years ago, and there was earlier talk about how long, when you don't have an appeal process, court cases can go. 6 years ago, I live in a residential and agricultural district. My next door neighbor wanted to build a 26-foot tall industrial building of 4,800 square feet so that he could run a body shop in it in a residential area. He went to the building inspector. The building inspector has zero training in zoning code or law. He has training in building inspection, and that's good and reasonable. But it is his job to rubber stamp or to stamp applications. He said, yes, you can absolutely put a 4,800 square foot body shop in a residential zone in the front setback and in the side setback. A lot of neighbors were outraged by this, and we went to the Zoning Board of Appeals. And that's another story, and I'll write a book on it someday. But what happened is you've got an unelected government employee who made a decision that impacted other people to the tune of hundreds of thousands of dollars. This, and at least the law today says that we have an appeal. We have a right to petition our government for redress of grievances, and we did. This bill would say everyone up and down this road who is losing $50,000 to $100,000 of property value, unless they are exactly next door or exactly across the street, has no ability to petition the government. There is even a hack here that one of my lawyer friends pointed out. If a developer wanted to do something underhanded that would drastically impact locals, he could buy a large piece of property, subdivide it so that he became his own abutter and there were no other abutters, and then no one else would have the ability to petition the government for redress of grievances if the building inspector, who again is not trained in zoning, gave him an illegal building permit. The goal of creating more housing for New Hampshire families is a good one. I'm very open-minded to it. But this is a quick and dirty hack saying government officials should be allowed to break the law and citizens should not be allowed to complain about it. So I vote against the OTP, and I encourage you to as well. Thank you.
Representative Lascelles is recognized to speak against the report.
Thank you, Mr. Speaker, and thank you, colleagues. All this business about abutters comes down to definitions. Who's an abutter? Who's an aggrieved party? Who is directly affected and who is not directly affected? If you have such an expansive definition of abutter, you could have somebody in California dragging out a development that's much needed. If you have a very restrictive definition, then you could have people who are directly affected who are not defined as an abutter. So that's what it all comes down to. We defeated the amendment which seek to expand the definition so that we would include some of those people who are directly affected. We defeated that. This bill, as written, strikes the current language that says aggrieved parties and leaves that kind of up in the air. So as far as I'm concerned, we're better off with current law, which gives a little bit more room for abutters than this bill as written. So please defeat the bill so we go back to current law. Thank you very much.
Representative Len Turcotte recognized to speak in support of the report.
Thank you, Mr. Speaker. I rise in support of HB 1359. There are two parts to this bipartisan legislation. The first removes extremely vague language from our current RSAs that allow an unlimited list of individuals or parties to unnecessarily delay an applicant's planning approval by using and abusing the appeal process to the Board of Adjustment. The two phrases that we eliminated in this language is an aggrieved person and one directly affected. What does that mean? What is an aggrieved person? What is one directly affected? Under the current RSAs, somebody in another county, in another state, conceivably in another country, is allowed to classify themselves as an aggrieved person. That is part one of the legislation that we eliminate. The second part is it adds new and very specific definition of the phrase directly across the stream or street from to the abutter definition and removing any doubts about the interpretation. Now, this definition was devised by two individuals who both have civil engineering experience in it. So although it may look a little technical, it is technical, but it's also very specific. And this proposed change came about while doing research on this bill. There was a Supreme Court case where there were very different interpretations of what that particular phrase of across the street or stream meant. So again, while the new definition looks complicated, it's actually very specific, and it leaves no room for interpretation. Now, we've heard some arguments, and I'll talk against a couple of them. One is the appeal process would not change the ability of anyone who can demonstrate they are directly affected by to testify in the initial planning phase or during the appeal process. The selectmen, the municipality's board, or local legislative body for appeals, any party to the action, and abutters still will have the ability to appeal. Now, if there are individuals who are not abutters or the list that I just named, they can certainly testify, and they can also certainly influence the long list of individuals I mentioned into delaying the process. Now, I mentioned at the beginning of the bill that this was a bipartisan bill, and it extends beyond the sponsors of the bill, which are bipartisan and include individuals on the other side of the wall. And it also supporting within the Municipal and County Government Committee. In somewhat rather rare occurrence, something we don't see very often in municipal and county government, outside parties and those who testified, I think every one of them were all in agreement with this legislation. And I think you all received a letter recently that included, and again, these 5 individuals are rarely on board with each other. The New Hampshire Realtors, the Housing Action New Hampshire, the President and CEO of BIA, New Hampshire Planning Association, and the NHMA. All were signatories of the letter that each of you received in favor of this legislation. So ultimately, the aim of the bill is to reduce costly and time-consuming frivolous appeals by unaffected parties. It will result in quicker approvals, faster construction, and therefore lower the overall cost. And these points should be very appealing to those who believe we need more housing at a faster pace. Make no mistake, there are many factors involved in our current housing situation, and most of them we have no control over. This legislation is but a small piece where we can reduce regulation, reduce bureaucracy, and reduce unnecessary delays. I ask that you press the green button, and Mr. Speaker, I am going to request a roll call vote. Thank you.
The questions on the Majority Committee report ought to pass on House Bill 1359. Representative Len Turcott requests a roll call. Is that sufficiently seconded? That is sufficiently seconded. This will be a roll call vote. Members, take your seats. The questions on the Majority Committee report about to pass on House Bill 1359, and this is a roll call vote. Representative Aylward is recognized for a parliamentary inquiry.
Mr. Speaker, if I know that impacts from a proposed land use project can be experienced well beyond the boundaries of an abutter's property that could affect such things as noise, traffic, water quality, water quantity, all of which could negatively impact the use and the value of one's property. And if I knew that testifying as a witness at a public hearing gives you no legal rights whatsoever, as opposed to being an appellant. And if I further know that the bill is overly restrictive in that it excludes non-abutting property owners within the municipality from filing an appeal with the CBA, even though they can demonstrate that their property is directly affected by a decision of a planning board or an administrative officer. And as such, this bill unjustly denies an aggrieved non-abutting property owner their due process rights at the local level. So would I now vote no and push the red button so that a more appropriate motion can be made?
Representative Howland's recognized for parliamentary inquiry.
Thank you, Mr. Speaker. If I know House Bill 1359 helps curb abuses to the zoning board appeal process, and if I know those abuses lengthen the appeal process and add great cost to projects, and if I know that it makes it virtually impossible to build affordable housing when that occurs, then would I push the green button to pass this helpful legislation?
Questions on the Majority Committee report about to pass on House Bill 1359. There's a roll call vote. If you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds. Have all members present had an opportunity to vote? The House will attend to the state of the vote. Choose 65 in the affirmative, 88 in the negative. The report is adopted. The Committee on Public Works and Highways, to which is referred House Bill 1253, an act renaming the Blair State Forest in Campton as the Jane Kellogg State Forest. Having considered the same, report the same with the following resolution. Resolved that it is inexpedient to legislate. Representative Bill Boyd for the committee. The question is on the committee report of inexpedient to legislate. Are you ready for the question? All those in favor say aye. Aye. All those opposed, nay. The ayes have it, and the report is adopted. The Committee on Public Works and Highways, to which is referred House Bill 1510, an act establishing a commission to identify barriers to and solutions for electric vehicle sales and use. Having considered the same, report the same with the following resolution. Resolved that it is inexpedient to legislate. Representative Bill Boyd for the committee. The questions on the majority committee report of inexpedient to legislate. Are you ready for the question? All those in favor say aye. Aye. All those opposed, nay. No. The ayes have it, and the report is adopted. Okay. The majority of the Committee on Resources, Recreation, and Development, to which is referred House Bill 1142, an act relative to requirements for relevant work experience before taking the exam to be a septic designer or installer. Having considered the same, report the same with the following amendment and the recommendation that the bill ought to pass. With amendment, Representative Will Darby for the majority of the committee. The minority of the committee, having considered the same and being unable to agree with the majority, report with the recommendation that the bill be referred for interim study. Representative Rosemary Rung for the minority of the committee. The amendment is 0653H, printed in House Record 9, on pages 52 to 53. The questions on the adoption of the amendment. Are you ready for the question? All those in favor say aye. Aye. All those opposed, nay. The ayes have it, and the amendment's adopted. Now on the main motion, the committee report of ought to pass with amendment. Are you ready for the question? All those in favor say aye. Aye. All those opposed, nay. No. The ayes have it, and the report is adopted. The majority of the Committee on Resources, Recreation, and Development, to which is referred House Bill 1208 FN, an act relative to permitting requirements for timber harvesting operations in a wetland. Having considered the same, report the same with the following resolution. Resolved that it is inexpedient to legislate. Representative Dan Wolf for the majority of the committee. The minority of the committee, having considered the same and being unable to agree with the majority, report with the recommendation that the bill be referred for interim study. Representative Suzanne Vale for the minority of the committee. For what reason does the member rise?
To put on the table.
Representative Renzullo moves that House Bill 1208 be laid on the table. Are you ready for the question? All those in favor say aye. Aye. All those opposed, nay. The ayes have it. House Bill 1208 is laid on the table. The majority of the Committee on Resources, Recreation, and Development, to which is referred House Bill 1483, an act allowing subdivision regulations concerning water supply. Having considered the same, report the same with the recommendation that the bill be referred for interim study. Representative Robert Harb for the majority of the committee. The minority of the committee, having considered the same and being unable to agree with the majority, report with the recommendation that the bill ought to pass. Representative Suzanne Vale for the minority of the committee. Representative McGee is recognized to speak against the report.
Thank you, Mr. Speaker. Good afternoon, everyone. HB 1483 protects home buyers and municipalities by enabling local control over the assessment of water adequacy for subdivisions. The bill does not mandate any action. It is enabling. Putting this language in statute brings focus to the issue of water resources in local planning. The Department of Environmental Services Water Division expert testified that this bill was consistent with the 2010 Water Commission report findings, where they found that there should be additional statutory language concerning the importance of water planning at the local level for housing development.
Can the members suspend for a minute? I don't know where everybody's going, but made a little noise. We can wait. Go on.
Coffee? Oh. Thank you.
Sorry that happened. Go on.
All right.
Yep, continue.
Thank you. So, as I was saying, there was a 2010 Water Commission report, and the findings in that report were that it was important to put something about local water adequacy into statute so that municipalities would be looking at that when they're considering developments. But at the time, the Commission was really unsure of how to accomplish that, and during the hearing, the expert that came in from DES's Water Department said that this bill would actually be consistent with what they were recommending at the time. And this bill is the result of 2 years' worth of work, and it was bipartisan in support and also in sponsorship. So I'm asking that we take that action that was recommended by first voting down this ITL motion. HB 1483 exempts community water systems and large groundwater withdrawals, so it's not overly burdensome. It keeps decision-making in the hands of local planners rather than trying to mandate a one-size-fits-all approach. It treats water as a high priority in the approval process, like we do with septic planning. HB 1483 is timely because, as we've heard today, New Hampshire's being asked to rapidly add housing stock to meet growing demand. This simple enabling legislation can make sure that local boards don't skimp on getting subdivisions right. This bill asks planning boards to prescribe minimum on-lot private well testing requirements to assure adequate water body supply for subdivisions as defined in RSA 674:36, Section 2. That is not the same as requiring expensive hydrology studies on every project. The intent is to create clarity between the municipality and the developer at the outset of the project on what is needed to support multiple new builds, while minimizing disruption to existing neighbors on private wells. We may all know someone who has had their well affected by a nearby development. This helps manage that issue. The only opposition to this bill came from the New Hampshire Realtors Association, and they're a powerful lobby, and of course, they're concerned with anything that might increase costs for their members' bottom line. But we have an obligation to protect the rights of our constituents when it comes to essential resources. There's nothing more essential than adequate water. Please vote no on the ITL, because now is the time to get this change onto the books. And vote no on the ITL because this workable bipartisan bill is favored by town planners. Thank you, Mr. Speaker, and I request a division vote, please.
Representative Harb is recognized to speak for the committee report.
Thank you, Mr. Speaker. First, I'd like to clarify, I believe that this bill is up for interim study by the majority, not ITL. Interim study. Although this bill, HB 1483, does propose enabling legislation, the committee did discuss, was it really necessary? Could not subdivision regulations of municipalities already be adopted to provide the regulations concerning water supply? We received no legal opinion that it couldn't already be adopted. The potential cost to developers in a market where housing is drastically needed was also a concern that if the bill were to be passed. The committee also discussed water supply and quality testing requirements prior to the issuance of an occupancy permit for a new residential home. Written testimony was received from the Commissioner of the New Hampshire Department of Environmental Services, DES, that a commission to study groundwater established by Chapter 176 of the laws of 2008 found that among its commission members, which represented a diverse group of stakeholders, there was not a consensus of whether local regulations of groundwater withdrawals was appropriate or necessary. It was for these reasons a bipartisan majority of the committee voted for an interim study to enable us more time to look into this question. So we'd ask you to please press the green button to support the bipartisan position. Thank you.
Questions on the Majority Committee report of interim study on House Bill 1483, and this is a division vote. Members, take your seats. The question is on the Majority Committee report of interim study on House Bill 1483. Members, find your seats, probably right where you left them. Representative Vales recognized for parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if I know that the building of new developments can and does affect the availability of water in the vicinity, and if I also know that this might not necessarily happen in a town like mine, like Nashua, but that it does happen in many other towns in New Hampshire, and if I know that House Bill 1483 is enabling legislation with bipartisan support, which means that no town is forced to participate, but if a town is having this problem, they can opt in, would I now press the red button on the motion of interim study so that another motion can be made, one that can get this legislation over to the other chamber for consideration by the people who meet there? Thank you.
Representative Renzullo is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. If I know that this bill requires a, quote, water supply study to be done prior to the subdivision being approved, and, Mr. Speaker, if I know that last year a similar bill requiring a hydrology study prior to subdivision approval was rejected by the committee due to high costs, long delays, and questionable efficacy based on DES testimony. And finally, no information was provided as to what this proposed water supply study actually entailed. Therefore, would it not be absolutely necessary for me to vote for the committee to exercise due diligence and interim study this bill to actually determine what a water supply study really means? Hopefully it's not a hydrology study in sheep's clothing, especially in light of the housing shortage and already...
The member will suspend. I think you forgot this was a PI.
Pardon?
Exactly. This is a PI.
I'm finishing, right? One sentence.
Well, but yeah, as long as it's a question.
All right, slap the green button, folks.
Sometimes this job is hard. The question is on the Majority Committee report of interim study on House Bill 1483. It is a division vote. If you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds. Have all members present had an opportunity to vote? The House will attend to the state of the vote. 182 in the affirmative, 165 in the negative. The report is adopted.
Harrington moves on to pass and offers the amendment. No debate on the amendment. No debate on
The Committee on Science, Technology, and Energy, to which is referred House Bill 1036, relative to assessment of cost effectiveness of these systems benefit charge, comes to us without recommendation. Representative Harrington moves on to pass and offers Amendment 0763H. The question is on the adoption of the amendment. You ready for the question? All those in favor say aye. Aye. All those opposed, nay. We're going to do a clarification vote. Nobody in, nobody out. Okay. If you are in favor of adopting the amendment, press the green button. If you're opposed, press the red. Voting stations are open for 30 seconds.
Representative Ankerberg.
All members present had an opportunity to vote. The House will attend to the state of the vote. 176 in the affirmative, 170 in the negative. The amendment is adopted. When we do voice votes on amendments, we like voice votes because they're fast, and I know it's late. I know you're weary, but still. Make sure that you're there. Make sure you put your voice out there, because that sounded like 2-1 the other way. All right. Now we're on the main motion of ought to pass as amended on House Bill 1036. Representative McGee is recognized to speak against the report.
Thank you, Mr. Speaker. The legislature sets policy, and regulators carry it out. In 2022, the House Science, Technology, and Energy Committee brought to you an urgent bill to rescue the New Hampshire Saves Energy Efficiency Program. We brought that bill after the Public Utilities Commission, or PUC, had broadly misinterpreted the legislative intent around New Hampshire Saves and opted to stall a pending 3-year program just as it was about to roll out. The utilities and our small weatherization businesses and all of their workers held their breath, hoping that the state could do something to fix what the regulators had broken for no apparent reason. That bill was HB 549, and as many of you may recall, we passed that at the Doubletree, and it was 343 to 0. Now, I know many of you have been in this House a long time. Very few things pass without even one person objecting, but that was a good day. And the bill was quickly signed into law by Governor Sununu. HB 549 put explicit guardrails around the PUC's administration of the New Hampshire Saves program. This bill offers to hand the guardrails back to the folks who caused that problem in the first place. HB 549 told the PUC how to handle the review process for New Hampshire Saves. We defined the tools that they would use in the review for cost effectiveness, and one of those tools, the evaluation, measurement, and verification study, was to be conducted by a professional under the guidance of the Department of Energy and the Joint Utilities. So we made everything very, very clear in statute. The lines of authority were defined, and the chaos that we had to fix with the PUC's handling of New Hampshire Saves would not be repeated. This bill puts conflicting language into the statute and creates competing lines of authority. There was no compelling reason given in the hearings for creating this competitive statutory language. So please protect our excellent New Hampshire Saves program, energy efficiency in general, which is an excellent value for all of us. There's no reason to give the regulators the authority to reset a defined policy. We set the policy, and they carry it out. We did that for them in a vote of 343 to 0. I respectfully ask that you vote no on the ought to pass so that a better motion can be made. And Mr. Speaker, I request a division vote. Thank you.
Representative Harrington is recognized to speak for the committee report.
Thank you, Mr. Speaker. This bill is a little different. We need a little background, what the purpose of this is. The purpose of the system benefit charge, it's paid for 100% by the ratepayers, and it's only one purpose, is to provide cost-effective energy efficiency projects for the state, period. We heard a lot of people were complaining about possible changes because it would affect the utilities. They'd have to change their planning, or it would affect the contractors who install energy efficiency programs. We don't really care. They should be lucky they're getting the money for this. There's only one purpose of this. Again, it's for the cost-effective energy efficiency projects. Now, the PUC developed this, and we had a lot of different things going on, but they came to, the Department of Energy actually came to us and asked us to give us some flexibility in the future. So let me tell you how, let me just read, so we tell you how flexible this is. What they're using right now is called the Granite State Test. And as a secondary one, it's called the Total Resource Cost Test. This law would say that when reviewing cost effectiveness for the program years through and including 2026, the Commission shall use the Granite State Test as its primary test, and the Total Resource Cost Test as a secondary. The Commission may consider modifications to the Granite State Test and different or additional tests developed through an adjudicative process and approved by them prior to commencement of any triennial period. And provided any such order is to be issued no less than 12 months prior to the beginning of that triennial period in which the test is to be applied. So it gives them flexibility to go back and know that things change. Discount rates change, interest rates change, ways of looking at efficiency could change with times. Basically, this Granite State Test was developed. It'll be 10 years by the time the PUC gets to revisit it. So that gives them the flexibility to do that. But it also builds in this 12-month period, so if we feel that they've done a really bad job, that gives us a year to turn around and say, no, don't do that. So it gives them flexibility to keep up with the times. Until HB 549 was passed, the PUC always had the authority to set those parameters. This is the first time we've ever changed it. So we're saying in the future, Allow them the flexibility of looking at possibilities because the world does change, circumstances change. Maybe the way we do energy efficiency cost evaluation needs to change. But either way, there's a safety valve in there. If the legislature doesn't like it, it has them a year to change it, to override that if want to. So please vote green on this. Thank you.
The question is on the motion about to pass as amended on House Bill 1036. Representative Sweeney requests a roll call. Is that sufficiently seconded? That's sufficiently seconded. This will be a roll call vote. Members, take your seats. The questions on the motion about to pass as amended on House Bill 1036. This is a roll call vote. Representative Wendy Thomas is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. Are they okay?
All good.
Okay. All right. Mr. Speaker, if I know this bill was presented as providing flexibility for the Public Utilities Commission to modify cost-effectiveness tests being used to approve the 3-year NH Saves plan, however, the tests currently being used have been agreed to by all stakeholders and placed in statute to provide clarity and consistency to the joint utilities who are charged with running NH Saves, so there is absolutely no need to modify them. And if I know this bill contradicts existing statutory language and brings confusion to a long-established process as to where authority rests for any cost-benefit analysis. And finally, Mr. Speaker, if I know this is exactly why the legislature stepped in 3 years ago to set clear guardrails protecting NH Saves funding, quantifying its growth, and limiting the PUC's authority to undermine the intent of the state's energy efficiency programs when we passed HB 549, would I now oppose the OTP motion by pressing the red button so that a different motion can be made? Thank you, Mr. Speaker.
Representative Vos is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if I know that one prominent state regulator said of the law under debate here this afternoon, and I quote, "If you like ratepayer-funded energy efficiency, you favor a low discount rate. And if you think ratepayer-funded energy efficiency is bad public policy, you prefer a high discount rate," which means that existing policy can be manipulated to favor a particular outcome, which does a disservice to our constituents. And if I also know that House Bill 1036 provides a more equitable framework for determining the cost-effectiveness of energy efficiency programs. And finally, if I know that good public policy enshrines objectivity and neutrality to the greatest extent possible, would I now press the green button to guarantee that New Hampshire gets the most out of its energy efficiency investments? Thank you, Mr. Speaker.
The questions on the motion about to pass is amended on House Bill 1036. This is a roll call vote. If you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds.
Representative O'Kelly. Representative Woodcock.
Have all members present had an opportunity to vote? The House will attend to the state of the vote. 184 in the affirmative, 169 in the negative. The motion is adopted. The Committee on Science, Technology, and Energy, to which was referred House Bill 1623 FN, relative to the state energy policy. The bill comes to us without recommendation. Representative Vos offers ought to pass and moves Amendment 0782H, printed in House Record 9 on pages 69 through 70. There will be a division vote on the amendment. Members, take your seats. Questions on the adoption of Amendment 082H? If you're in favor of adopting the amendment, press the green button. If you're opposed, press the red. Voting stations are open for 30 seconds. All members present had an opportunity to vote. House will attend the state of the vote. 182 in the affirmative, 169 in the negative. The amendment's adopted. Now the motion is ought to pass as amended. And Representative Kaplan is recognized to speak against the motion.
Thank you, Mr. Speaker. Mr. Speaker, HB 1623 represents a radical reversal of longstanding energy policy which has served our state well, and also an extreme departure from our constitutional relationship to the federal government, its agencies, and regulations. This bill replaces the well-balanced current energy policy which integrates the private sector's need to make a profit with the public's need to receive a beneficial service. Replaces that with a protectionist anti-market screed, what one of the testifiers in our public hearing called a spaghetti code, an unworkable jumble of contradictory language and terms which seeks to place its thumb on the scale in favor of clinging like a security blanket to traditional fossil fuel energy sources and power generating stations that don't even belong to us. This bill seems to be motivated out of an irrational fear of an energy transition that we've been in for quite a time now, and which has accelerated recently due to our acknowledged need to wean ourselves off of fossil fuels. Are there examples of where the government has come in and shut down power generating stations and destabilized the grid? The fictional situation which seems to motivate the authors, the proponents of this bill. I don't think so. As a matter of fact, recently the Biden administration has responsibly slowed down its rulemaking on several fronts in order to not destabilize the electricity markets and transition too quickly. This bill asserts, quote unquote, the state's police power to protect and defend power generation within our state's borders. In other words, it would have the state expropriate private companies' property and production for the state's own needs. Not a good look for the live free or die state. This police power of expropriation would depend on our Department of Energy's role in overseeing and unwinding federal rules and regulations that would theoretically conflict with this newly established internal energy market. This is a role that the department politely declined in our public hearings, saying they didn't think it was a viable or productive use of its time, and instead insisting that we continue to defer to the independent system administrator of our regional transmission system, the ISO New England. In other words, the work that this bill wants done can't be done by the agency that would be charged with carrying it out. This bill claims to be market-based and neutral in terms of the energy sources that it would seek to develop, but in the very same section says that the state of New Hampshire would seek to develop, quote, dispatchable and reliable energy sources, which is code language to undermine renewable energy development in our state. It's anything but market-based and neutral. As a matter of fact, the market is clearly spoken across the country, and renewable energy plus storage, which is dispatchable, is the cheapest source of new generation and is leading the charge to electrify the country. By asserting the state's right to set up and regulate this new internal energy market, this bill clearly stands in opposition to the market forces it's claiming to defend, since we are part of this regional system. And this bill intends to destroy and replace this system with a top-down, state-managed, protectionist, closed-off energy market, which hasn't worked anywhere in the world where it's been attempted. We are not our own grid, nor should we seek to be. HB 1623 is legally questionable. Nothing says interstate commerce more than a regional transmission and distribution system. It's physically impossible. Electrons don't stop their flow at the state line. And it's economically nonsensical. We don't own the resources, and we don't have the scale in New Hampshire to develop self-sufficient and affordable energy systems on our own. Nobody spoke in favor of this bill. The New England Power Generators Association, which represents the power plants that this bill has set its sights on, called it an extremist intervention. An extremist intervention, I think that actually understates it. Frankly, I find it surreal that I'm up here defending the New England power generators against a state takeover by the state of New Hampshire, put forward by mainstream legislators in this chamber. Because, you see, the New England power generators, they get it. We are part of an energy transition that is best managed on a regional scale under federal oversight. So please join me and turn the rapidly dispatchable switch on this hot mess, this ideologically motivated, not ready for prime time, out-of-touch bill, and please hit the red button for to pass so a new and better motion can be made. Thank you, Mr. Speaker, and I request a roll call.
Representative Vos is recognized to speak for the committee report.
Thank you, Mr. Speaker. We're lucky. We live in an age of energy abundance. Energy is the foundation of our economy. Energy has become the lifeblood of our civilization. Try to imagine what our life would be like if all the medical devices in the hospitals around our country and our world weren't able to operate because we had no electricity. Imagine what our life would be like without transportation, without communication, without the ability to manufacture goods. All of that is provided by energy. And we're lucky that we live in an age of energy abundance. But that energy abundance is kind of under attack. Our state energy policy should focus on three principles. And those principles are reliability of energy supply, use of any and all energy technologies, and the importance of market forces and market signals to keep that energy flowing and to keep it affordable. House Bill 1623 enshrines those principles into state climate policy. It replaces the 88-word run-on sentence of RSA 378:37, which has been described by one of our prominent state regulators as a melange of mixed messages, with a clear statement of these three energy principles. But it does more than that, because as I said a moment ago, we are under attack. The Federal Energy Regulatory Commission, the North American Electric Reliability Corporation, and many of the country's regional transmission operators have been warning for some time that closing existing power plants before suitable replacements are online jeopardizes the reliability of our electricity grid. Just 2 days ago, the CEO of one of those regional transmission organizations, John Baer, said this. He said, quote, "The transition that is underway to get to a decarbonized end state is posing material, adverse challenges to electric reliability." The attacks are legion. There are many of them out there, such as halting the permitting of new liquefied natural gas export terminals, new EPA rules on particulate matter that affect not only power generation, but truck and auto use as well, lower methane standards that affect pipelines and power generators, state bans on gas stoves. The attacks go on and on. HB 1623 acknowledges the responsibility of the state of New Hampshire to guarantee the health of our citizens by protecting our supply of essential power. Importantly, it asserts our constitutional 10th Amendment sovereignty regarding any non-congressionally mandated closure of a power generating station. It gives us leverage to oppose regulatory overreach. It goes on to acknowledge and establish that market forces are what should drive the governance of our state energy policy. HB 1627 would allow would allow a generator in our state who receives regulatory information that would make it economically infeasible for him to continue to operate, to approach our New Hampshire Department of Energy and ask them to investigate whether that's the case. And if it is, the DOE could ask the DOJ to intervene on behalf of that generator. This is important legislation. I ask for your support. Thank you, Mr. Speaker.
The question is on the motion about to pass as amended on House Bill 1623. Representative Kaplan requested a roll call vote. Is that sufficiently seconded? That is sufficiently seconded. This will be a roll call vote. Members, take your seats. The question is on the motion about to pass as amended on House Bill 1623. Representative Corman is recognized for a parliamentary inquiry.
Thank you, Mr. Speaker. If I know that when my friend from Epping introduced this bill in committee, he called it the New Hampshire Energy Independence Act. But if I also know that we are part of the ISO New England grid and inexorably tied into it, and that energy produced in New Hampshire flows out of state and energy produced out of state flows into New Hampshire, and if I also know that New Hampshire produces no oil, gas, or coal, so that anyone that needs fossil fuels, whether it be a power generator or home heating, must be importing from out of state, then, Mr. Speaker, would I be forced to conclude that New Hampshire energy independence is but a pipe dream and press the red button?
Representative Vos is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if I know that our current climate policy has been called a melange of mixed messages by one prominent state regulator, and that it should instead guarantee the health and safety of our citizens by protecting our supply of essential power. And Mr. Speaker, if I also know that overzealous regulatory edicts can directly affect a generator's financial viability and might force its premature closure. And finally, if I know that this bill asserts the constitutional 10th Amendment sovereignty of New Hampshire to fight the untimely shutdown of a power generating station, would I now press the green button to give New Hampshire leverage to oppose regulatory overreach? Thank you, Mr. Speaker.
Questions on the motion about to pass as amended on House Bill 1623 FN. This is a roll call vote. If you're in favor, press the green button. Opposed, press the red. Voting stations are open for 30 seconds. All members present had an opportunity to vote. The House will attend to the state of the vote. 184 in the affirmative, 168 in the negative. The motion is adopted.
For what reason does a member from Manchester rise?
I'd like to place the last debate in the permanent.
Okay, I can't.
I'd like to place the last debate in the permanent journal, please.
Without objection, so ordered. Thank you.
All right, Mr. Speaker. We have the majority report, minority report. There is a one-on-one debate on the amendment, division, and then we have a debate on the OTPA.
Okay. The majority of the Committee on Transportation, which was referred House Bill 1118, an act relative to the issuance of driver's licenses for aliens temporarily residing in New Hampshire, having considered the same, report the same with the following amendment and the recommendation that the bill ought to pass with amendment. Representative Stephen Smith for the majority of the committee. The minority of the Committee on Transportation, to which was referred House Bill 1118, an act relative to the issuance of driver's licenses for aliens temporarily residing in New Hampshire, having considered the same and being unable to agree with the majority, report the following resolution. Resolved that it is inexpedient to legislate. Representative George Sychterz for the minority of the committee. The question before the House now is on the amendment number 0637H, printed in House Record 9 on pages 51 to 52. Are you ready for the question? I'm sorry, there is a debate on the amendment. The chair recognizes Representative Walsh to speak. I'm sorry, Representative Sychterz for a PI. Oh, he's doing both. Okay. Representative Sychterz is recognized to speak.
Mr. Speaker and colleagues, I want to begin by stating that this bill began life as a good faith effort to clarify and even to be a housekeeping bill that non-citizens could, and how they would obtain and when they could obtain a driver's license. Those folks include people who come to work here, and they include folks who come to, young people who come to study here. And all of my comments today will be related to people who are here legally in all circumstances. Instead, an amendment has been introduced. And for the moment, I'm going to keep my remarks to the amendment itself. The amendment included language that completely contradicts current DMV rules and practices. So currently, asylees who are here legally in the country will wait to have their hearing. In some cases, those hearings determining their permanent status can be delayed. In fact, it can be delayed 10, 12 years, even more. In the meantime, the federal government has made it is part of the federal government to say, if you do not have your hearing within 1 year of the time that you apply for asylum, then you will be given a work permit. And then the DMV, under its current practice, would say, well, you're here legally, you have a work permit, you should be able to drive, and by the way, you can, as long as you come down and you take the written exam, you take the practical exam, and you prove that you are a capable driver. The amendment changes all of that. What's really unfortunate about this is the amendment also is unclear about whether people who have already obtained their driver's license in this manner will be able to renew that driver's license. And I want to tell a very brief story about how, as an example of how this works practically. We have a young person living in the city of Lebanon, arrived here more than 10 years ago. His son began school in first grade, I believe. He's in high school now. His young daughter is in the elementary school still. He volunteers his time with a couple of the city's commissions, so where resident input is important, and he works full-time and supports his family. He works for a nonprofit agency that provides services to the less needy. He pays more than 40%, maybe even 45% of his income for rent. So it's not an easy row for him to hoe, but he's doing this and he's doing well and he's thriving. He has a driver's license. What happens when he renews next time? It is unclear from this amendment. The second part of the amendment that is problematic from my perspective is that it will require all non-citizens to have their license marked them as a non-citizen. Now, here's why this is, in my mind, an anti-business measure. Because right now, there are lots of people who come to work in businesses who have skills, who are non-residents, and they are able to do so because they can get their driver's license and they can get around and do the work that needs to be done. We have institutions of higher learning who are providing education to students who come, and they also receive a driver's license under this mechanism. They are now going to have to go through additional steps in order and put citizenship on their driver's license. I would like to remind the House that we have voted consistently over the years not to accept the concept that there should be a citizenship marker on driver's licenses. We have done so consistently because of concerns, privacy concerns. And so I would urge all of you to, first off, Mr. Speaker, I'll request a division vote on this, and I would urge all of my colleagues to press the red button on the amendment.
The question before the House is on the adoption of Amendment 0637. The chair recognizes Representative Walsh to speak in support of the amendment.
Thank you, Mr. Speaker. Where to begin? I'll start off by saying that the previous speaker was correct on what this amendment does. And that's the problem. That's why we have an amendment, because the DMV is actually giving temporary work authorizations to people with pending asylum and refugee cases, in spite of the fact that they told me for months that they were not. Now, the bill does, and I'll get the actual words, say that no longer will these work authorizations be recognized. Now, why would we do this? Well, I don't know, maybe it's me. Maybe it's got something to do with the millions and millions of people claiming refugee that are coming across our borders, which is going to be equivalent to tens of thousands in the state of New Hampshire. Maybe it's got something to do with the fact that the current administration is ignoring treaties and agreements we've been in since at least 50 years, called the Third Safe Country Agreement, which means that only abutting countries are we responsible for accepting refugees. You can't jump 6. You can't get on a plane and fly across the ocean to Mexico and then come here and claim asylum. It's against our own laws. Maybe it's because they're ignoring our third country agreement, it's reported that over 71% of the refugee claims are not even from eligible countries. Of the 29% that are maybe from eligible countries such as Mexico, they still need to prove either religious or political persecution. To come here just to seek a better life is not legitimate reason to claim asylum. It's just not. There are other avenues for that to happen. I'll give you one more reason that might sway your opinion on why we should be doing this. On the southern side of the Mexican border, there are tens and tens of thousands of identifications, visas, passports, and currency from, right now they're counting about 180 countries from around the planet. Why are these people leaving their stuff in Mexico before they come here? Because they don't want us to know who they are. The bottom line is, I'm not going to get into the rest of the amendment because this is the controversial part of it. But if you truly believe that driving on our ways is defined as a privilege, and a privilege reserved for our law-abiding citizens and the visitors, or in this case, the people that actually are completely vetted and adjudicated through the asylum courts, please support the committee amendment. Thank you, Mr. Speaker.
The question before the House is the adoption of Amendment 0637. This will be a division vote. Members will kindly take their seats. A roll call has been requested. Is that sufficiently seconded? It is sufficiently seconded. This will be a roll call vote. The House will come to order. The question before the House is on the passage of Amendment 0637. This will be a roll call vote. Representative Sychterz is recognized for a parliamentary inquiry.
Thank you, Mr. Speaker. If I know that my last name is Veyu or Sandoval or perhaps Manjapudi, that our families, those families, they came here to gain a better life. If I know that the amendment adds two significant new requirements, including a citizenship marker, which we have voted consistently against, and a prohibition for asylees. We're not talking about refugees at this point. We're talking about asylees only. Asylees to get a driver's license while they're waiting for their permanent hearing. Would I now press the red button so that the amendment could be defeated?
The question before the House is the passage of Amendment 0637. This will be a roll call vote. The chair recognizes Representative Walsh for a parliamentary inquiry.
Thank you, Mr. Speaker. If I know that no agricultural, educational, or hospitality or any other visa holder will be affected by anything in this amendment, if I further know that the majority of asylum claims are from ineligible countries, and based on the volume of discarded IDs and currencies at the border, that all claims should be adjudicated before privileges are given. If I believe that work authorizations are the way around to the asylum process, which is overwhelmed by the millions of claims, then would I now press the green button? Thank you, Mr. Speaker.
The question before the House is on the passage of House Bill 1118 as amended. The chair recognizes Representative Sychterz for a parliamentary inquiry. Yeah, we did in 1 minute. The question now is on the passage of the bill as amended. On the vote on the amendment. It's been a long day. The question before the House is the passage, is the vote on Amendment 0637. This will be a roll call vote. If you're in favor of the bill, you'll press the green button. If you're opposed, you'll press the red button. All the voting stations? An open vote. Have all members present had an opportunity to vote? The House will be attentive to the state of the vote. With a vote of 180 to 167, the motion on the adoption of Amendment 0637 passes. The question now before the House is on the motion of order pass as amended. The member.
I have a motion to make.
I'm sorry. Well,
Mr. Speaker, if you may, I would like to make a motion, or make a request.
State your request.
I would like to move that the previous remarks on the amendment be put in the permanent journal. You have to do the whole bill? Okay.
We'll make it a package. Yeah. The question now before the House is on the ought to pass as amended. Yeah. The chair recognizes, now once again recognizes Representative Sychterz for a parliamentary inquiry. Yep, PI.
Thank you, Mr. Speaker. Colleagues, you heard my previous arguments. I'm not going to repeat them, but I will bring up one final and additional point relative to the bill as a whole. Within the bill's original language.
I'm sorry, he's speaking on the bill.
I get to speak.
That's fine. You're fine. You're speaking on the motion to ought to pass as amended.
Yes.
You're good.
Thank you, Mr. Speaker. So again, I'm not going to repeat the previous debate on the amendment, but I do want to point out that the original bill in its original language did have also a requirement that changed some of the language of how the DMV would process requests for non-residents to get their driver's licenses. And they changed the language from may to shall. And I would point out that during testimony for that, we heard very determined, very forceful language and testimony from the DMV of the problems that would create for them in administering that. And so for that reason alone, I would urge my colleagues to, again, I request a division vote and that they would push the red button.
The question before the House is on the passage as amended of House Bill 1118. The chair recognizes Representative Smith to speak in support of the motion.
Thank you, Mr. Speaker. This is weird. Hey, I'm over here now. So, I don't know why I put these on. I have nothing to read. So here's what happened. Somebody asked me a question, and I looked up a statute. Unless you have an hour on your hands, never do that. So I looked at the statute that provides for licenses for people who are here temporarily but legally, and there were some problems. So it is comprised pretty much of three things. One, identifying the people it applies to. Two, specific things that DMV should do to make sure that they actually know how to drive before we give them a license. And three, the terms. So, first, These were like if you took these things and put them in a shredder and then pasted them back together out of order. They were all over the place. You'd have something to identify the person, the next one, oh, and by the way, see if they have a document that shows that they know how to drive. By the way, this applies to people. A mess. I don't know how it happened, but we're going to fix it. So what I did was I went through this, and the stuff for identifying the people, that was easy. It goes in the first section. Now, we'd kind of like to know they know how to drive, right? How does a director do that? Well, previous legislature went through the trouble to identify like 5 different things that the director may look at. Doesn't say he actually has to do any of them. So we took the time to identify these 5 things, and then the director can look at it and go, nah, too much trouble, and move on. Not good enough. So now it does say that they have to do at least one of these things. Now, the DMV director was concerned that some nefarious director would pick the hardest of these 5 things, to kind of make it really hard for these folks to get licenses. He can do that now. Matter of fact, it's the way it's labeled. He may do all 5 of them. Now he can only do 1. That's better, not worse. So, we reorganized the statute. Some of these folks who are here legally might not have a Social Security number. There was no carve-out for the statute that explicitly requires one. That's been fixed. They're here temporarily. I know a tech company that I worked for, we would get engineers in from overseas for like 2 years. Why would you want them to have a New Hampshire license? Well, because our insurance company on the company vehicles was a lot happier if they had New Hampshire licenses. So it makes good business sense to do this. The bill also now requires that if they show a 2-year visa, their New Hampshire license, going to be good for 2 years. The director has to sync up the duration of the New Hampshire license with the duration of their stay. So it cleans it up, it just makes good sense, and I hope you can support it. Thank you, Mr. Speaker.
The question before the House is on the motion of ought to pass as amended on House Bill 1118. This will be a division vote. Roll call has been requested. Is that sufficiently seconded? It is sufficiently seconded. This will be a roll call vote. The question before the House is on the motion of ought to pass as amended on House Bill 1118. This will be a roll call vote. The chair recognizes Representative Sychterz for a parliamentary inquiry.
Thank you, Mr. Speaker. If I know that this was a good faith effort to try and clean up the language, and I agree with my colleague about the efforts that he was making, but I also know that 2 very difficult and, for me, problematic amendments were added to that bill that go into all of the things that I talked about, where a citizenship marker on the bill would be required for these folks now, and where asylees would not be able to get a license to drive. And if that happens, how are they going to support their family has to be the question. Would I now vote red so that another motion could be introduced?
The question before the House is on the motion of ought to pass as amended on House Bill 1118. This will be a roll call vote. The chair recognizes Representative Walsh for a parliamentary inquiry.
Thank you, Mr. Speaker. If I know that this really shouldn't be a controversial bill, it just makes some common sense corrections to law. And if I will always remember that driving in New Hampshire is a privilege, would I now press the green button?
Question before the House is on the motion of ought to pass as amended on House Bill 1118. This will be a roll call vote. Voting stations will now be open for, if you're in favor of the bill, you'll press the green button. If you're opposed, you'll press the red button. Voting stations will now be open for 30 seconds. Have all members present had an opportunity to vote? The House will be attentive to the state of the vote. Yep, that's. Yeah, on the motion of order pass as amended, the vote being 179 to 166, the motion carries, and Representative Sychterz is recognized for a motion.
Yes, Mr. Speaker, thank you. I move that the remarks from the debate on the amendment and the bill be placed in the permanent journal.
Without objection, so ordered. Representative Sweeney is recognized.
Thank you, Mr. Speaker. Mr. Speaker, having voting on the prevailing side on HB 1412 relative to court reporters, I move reconsideration and urge the body to vote no.
No. Just go to the vote. The question before the House is on the motion to reconsider House Bill 1412. This will be a voice vote. All those in favor say aye. Aye. All those opposed say nay. Nay. The nays have it, and the motion is defeated. Representative Sweeney is again recognized for a motion.
Thank you, Mr. Speaker. Having voting on the prevailing side of HB 1623, I move reconsideration and urge the body to vote no.
Question before the House is on reconsideration of House Bill 1643. This will be a division vote. Correct that. House Bill 1623. Members will take their seats. This will be a division vote. Yeah. The question before the House is on the motion to reconsider the vote on House Bill 1623. If you're in favor of the motion, this will be a division vote. If you're in favor of the motion, you'll press the green button. If you're opposed, you'll press the red button. Voting stations will now be open for 30 seconds. Have all members present had an opportunity to vote? The House will be attentive to the state of the vote. With a vote of 165 yea, 179 nay, the motion fails. Representative Sweeney is recognized.
One last time, Mr. Speaker. Having voted on the prevailing side of HB 1118, I move reconsideration and urge the body to vote no.
The question before the House is on the motion to reconsider 1118. This will be a division vote. Members will kindly take their seats. The question before the House is on the motion to reconsider the vote on House Bill 1118. If you're in favor of the motion, you'll press the green button. If you're opposed, you'll press the red button. Voting stations will now be open for 30 seconds.
Representative Munns, number 3. Representative Shapiro. I need a yes or a no. Thank you. All set.
If all members present had an opportunity to vote, the House will be attentive to the state of the vote. With a vote on the motion to reconsider 167 yea, 178 nay, the motion fails. Yeah. Without objection, the remainder of the bills will be special ordered to the regular place on the next week's calendar. Chair recognizes the majority leader for a motion. Third reading motion.
Resolved that the House now adjourn from the early session, that the business of the late session be in order at the present time, that the reading of bills be by title only and resolutions by caption only, and that all bills ordered to third reading be read a third time by this resolution, and that all titles of bills be the same as adopted, and that they be passed at the present time, and when the House adjourns today, it be to meet Thursday, March 14th at 9 a.m. Oh, we changed it, 10 a.m. 10 a.m.
The question before the House is on the third reading motion. All in favor say aye. Aye. Opposed, nay. The ayes have it. We have one unanimous consent. Will the members please keep the noise down? The chair recognizes Representative Schmidt. The House will be in order so the member can speak. It's the only unanimous consent we have, so you may want to listen to our friend from Dover.
Thank you, Mr. Speaker. So please, folks, 1 month ago, February 7th, an American helicopter went down in California. The Marine crew all died in the crash. Ordinarily, I might not speak about this on the House floor, but the pilot of the helicopter was Captain Jack Casey of Dover. I didn't think I knew Jack Casey, and indeed I didn't, but I know his father and his uncle and his grandfather, and so I'd just like to read a few remarks from his obituary, which I cleared with his grandfather as something that he would appreciate being done. So, as I say, ordinarily I wouldn't do this, but when Jack took the oath of office and put on that Marine Corps uniform, he's not just a resident of Dover anymore. Now he belongs to all of us. So if you will, just wait a second while I pull this up. I have to say, when I attended the wake, there were thousands of people from Dover, thousands of people. I got it right here. As a leader, he would carry people's burden and help them find a solution. When in doubt, flat out. Drama was not in his vocabulary. Leading by example in a calm, convincing manner, he did the right thing, whether or not someone was looking. He was a fiercely loyal husband, son, brother, and friend. Our universe has lost a precious, rare, amazing soul. Honor him by living life to the fullest. Be like Jack. Thank you, Mr. Speaker.
I also have a moment of silence in memory of Captain Jack Casey, United States Marine Corps. The remarks of our friend from Dover would be placed in the permanent journal.
Thank you, Mr. Speaker. Thank you, colleagues.
Representative Osborne moves that the House stand in recess for the purpose of introduction of bills and road bill amendments and road bill reports, vacate motions, and receiving messages. Are you ready for the question? All those in favor say aye. Aye. Opposed, nay. The ayes have it. The House is in recess until Thursday, March 14th at 9 a.m. I'm sorry, 10 a.m. You can sleep in.